Okay. Good afternoon, everyone, and welcome to the Senate Judiciary Committee's meeting of April 5th, 2022. We're going to go ahead and open the hearing, opening the day with a hearing on House Bill 1518 and recognize the prime sponsor, Representative Belanger. Good afternoon, Representative.
Good afternoon, sir. I wouldn't be late for your representative. Of course not. Thank you, Senator and fellow members of the committee, Madam Chair. For the record, my name is Representative Cody Belanger. I represent Rockingham District 9, which is Epping, also known as the center of the universe. We have bumper stickers, Senator. Unfortunately, for those in the audience, and I'm not sure if everybody here received it, but I came upon this issue, and I hope you have the, as amended by the House. But the bill that was outside on the desk was not the one that I will be reading from today. It has been it's been taken care of now. So if anybody wants to follow along, it's out there. So one of the things that we recognized in children and family law was that there is no home study done in the first initial process of an adoption. This committee heard my bill regarding adoptions last term, as did children and family law. So I sought to correct this issue that is not being done. I understand wholeheartedly that there are significant hurdles that I do want to work with to find a solution for. One of those being the fiscal impact. It is difficult to assume that every person who has obtained a guardianship can always, and it's difficult to assume that they can always pay for it. That I recognize. So finding a solution to pay for that is incredibly important. In its initial, in the bill as it was initially drafted, it was a $125, I call it a placeholder. I hadn't heard from any stakeholders as to what they thought the cost might be, so I just placed it in there. Because at the time when it was heard in the Senate, the House, I still had not heard. So we just 86'd it, struck it out. The initial effect will take, so the bill would take effect in January 1st, 2023. Speaking to some stakeholders, they think that that might be a little too soon. Perhaps maybe looking at another effective date. It is important to recognize that this process is not currently being done now. And as much as I hate adding bureaucracy, we're talking about children, protecting the safety of children, and just ensuring that that's being done and making sure that the home is a safe environment. That's all this is trying to accomplish. In a lot of instances where a family may, a guardian may receive consent from a parent. If said parent gives that consent, it gives you an opportunity to not have that the home study waived. That was a compromise in children and family law in the House. I think this does, all it says is within 30 days, we shall, the agency, doesn't matter what agency, it's not specific, shall within 30 days issue a report to the court and to the guardian. Obviously, it's important to ensure that if a report is given, the guardian has access to that report as well. All it says is indicating that the home is a safe environment for the minor child. If it does mention that it is unsafe, you must list the reasons as to why it is unsafe and allow for the family to correct those issues over 30 days. It could be something as simple as having a pool unclosed, right? There's no gate to the pool, so just maybe ensuring that there's a gate. That can be considered unsafe because an unsupervised child may decide to go face first into the pool and you don't know. So with that, it's a very simple bill in its entirety. It's got good merits, but I welcome and encourage assistance in trying to figure out how we pay for it, because as a freshman, I'm not so keen on all those things.
Thank you very much for your testimony. Are there any questions from the committee? I have a question. So you're saying that right now there is no review when a child is being placed into a guardianship of minors, that there's no review right now?
Specific to a private guardianship, sorry, thank you, Madam Chair. Yes, specific to a private guardianship. Obviously, DCYF has their policies. This is separate. So for my example, and this is what kind of sparked this, I have adopted my nephew. And nobody in a 3-year time span prior to the home study adoption was anybody visiting to check to make sure my home was safe. Now, I have a safe home, but there was no assessment of my home to ensure that it was safe in that 3-year process.
Okay. My second question is, by the time this process starts, they've got to receive, 60 days, within 60 days, and then they have another 30 days. So for 3 months, a child can be placed into an unsafe environment. Are you okay with that?
No. Obviously, thank you for the question, but it was a compromise. And I certainly think it should be done much sooner than that. But how logistically that gets worked out per individual is difficult. I will admit that, based on schedules.
Okay. Thank you very much for your answering the questions. Are there any other questions? Senator French?
Thank you, Madam Chair, and thank you, Representative. You kind of glossed over agency. What would that be? What kind of agency? Who would run it? A state agency, is it? Or is it a private agency? And line 18.
Thank you for the question, Senator. So basically, when it says agency is approved and licensed by the Department of Health and Human Services, so yes, it would be Beckett Family Services, Waypoint, Easter Seals, those agencies that are approved and contracted by the Department of Health and Human Services that are approved and licensed by DHHS.
And who would appoint them?
I'm sorry.
Who would appoint them for this child care visit? They just wouldn't show up. Would they be appointed by the courts, or who would be appointing them to go make this visit?
Thank you for
By the court?
Thank you for the question, Senator. So in my experience, through the adoption process, you seek that out yourself. So while it is a lack of oversight over here on my part, I think it should definitely be addressed for sure.
The one more question, please.
Yes.
So is there a difference between your legal rights as an adoptive parent and one who has only guardianship over a child?
Thank you for the question. So as an adopted person, they are my child from set forth. As a guardian, the only difference is that I'm not their parent, quote unquote. I'm their guardian until age of 18 or termination of guardianship set forth by a court order. So I am, as a guardian, you are still legally responsible, financially responsible, healthcare responsible. The only difference is you're not legally the parent. It's not shown on your birth certificate that you're their parent.
So just one quick follow-up is, so in your case where you are the adoptive parent, you wouldn't be subject to any of these home safety visits because it's your child, you're not the guardian, correct?
Thank you for the question. I think, so in my instance, prior to being the adopted parent, whatever, prior to being the adoptee's parent, I was the adoptee's guardian. So
Good.
I was not in that time frame of 3 years prior to the adoption. There was no home study or safety check or safety visit that was done.
Got it.
So yeah.
Thank you.
I hope that answers your question.
Senator Whitley has a question.
Thank you, Madam Chair, and thank you for taking my question. Are you aware of any circumstances where, let's try this. Is that better? Are you aware of any circumstances where a child was placed in the home of a guardian and because a safety visit wasn't done, something occurred to the child?
So I'm not privy to that personal information, and thank you for the question, Senator. I think New Hampshire is very good about kicking the can down the road in child safety. We have seen that time and time again. And it's kind of one of those things where just because I'm not aware of any specific situation where that's not the case, doesn't mean that it shouldn't happen. And I don't mean that disrespectfully to anybody in this legislature or past legislatures. It's just sometimes, speaking from personal experience, being in the system myself as a child, both at JJ and DCYF, we're not very good about protecting children sometimes. And it's just one of the things that we forget about or don't pay full attention to, unintentionally, of course.
Senator Khan?
Thank you, Madam Chair. Representative, two questions, Madam Chair. One, how did the House deal with the financial question?
Thank you for the question, Senator. So in the initial, there was not a fiscal note on it in the initial piece. It did not go to fiscal in the House.
Got it. I guess we put the fiscal note on there.
I guess so. I don't know.
Don't know either.
Okay, so yes, we did. Okay,
Second
yes,
question.
second question.
On line 19, it says the home visit may be waived if the parent or parents give consent of the guardianship. Has that created some discussion and concern? Meaning, doesn't the state have some concern that if the court has determined that guardianship needs to pass from the parents, wouldn't the state want to assure that there was a home inspection?
Yes, Senator, thank you for the question. So I think when you read line 19, it says the home safety visit may be waived if the parent or parents gives consent of guardianship. And to me, what that says is that in the instance where a parent decides to leave their child with a grandparent or an aunt or an uncle, it is their assumption, right? We always want to assume that a parent can make that ability, or, perhaps and this is an example that one of my colleagues in the House used, his parents decide to go and get a divorce. In that instance, the parents are fully capable, but going through the divorce process, they agree that it is in the best interest of their child to go to the grandparents. And the grandparents raise them. And so in the instance where the parents have given full consent, and we always want to assume that parents know how to parent their kids, that they gave consent for the guardianship to go to the grandparents. And that's how I read that line, sir.
Or another relative, Mr. Chair. I just want to understand this one, although maybe I don't need to run just yet. It could be anybody, right? I imagine a grandparent, but the waiving, it seems like a serious matter that prior to that, even if it's a small inspection, just to make sure that the safety of the child is the purpose for any inspection, right? So I don't know that just because it's a relative that the state ought to consent to waiving that inspection.
I'm sorry, Senator, was there a question there? I may have missed that.
Do you believe? I guess you do. I guess you do believe then that a waiving at the parent's designation is something that the state ought to endorse. That's what I take from your answer.
Thank you, Senator, for the question. It's never safe to assume what I do or do not condone, but it would be important to recognize that there should always be a form of waiver. In any instance, in the case that a child is placed with a relative, or in this case where this committee heard, I don't remember the bill number off the top of my head, but my bill that was crossed over last term in regards to the adoption process, there is also a waiver form in that as well. That waiver, excuse me, not waiver form, just waiver in general. I apologize for the misspeak. The waiver allows for an adopting parent to include, to waive a home study that was done, to waive the home study out of the picture if a child has been living in their home for 2 consecutive years and that person who is adopting them is a relative, meaning aunt, uncle, cousin, grandparent, what have you. In the instance where if you're not related to that child, that waiver would not exist. So you could, in this instance, add that a guardianship to a relative. I wouldn't be completely unopposed to that. But completely striking out that language on line 19 through 20, not having the option to waive if a fully capable parent, which again, I always want to assume that every parent is fully capable of being a parent. We don't want to assume that every parent who gives guardianship is a bad parent. That there is an option for waiver moving forward. I think that's important as this issue is an important one that's not being done, but should be done.
So Representative, in
Thank you,
summary of
Representative.
his question, I think your belief is that parents normally and generally know what's best for their kids. And that's what you're saying.
Despite my own personal experiences with parents, them not being great, yes, Senator, that would be.
Thank you for
that
your
would be my
great testimony. Any other questions, Senator Whitley? Seeing none, thank you for your excellent testimony as always, Representative. Keith Cunning, you wanted to speak. It doesn't say if you're pro or against, but come on down. Good to see you. How you doing today?
Good afternoon. This is one of those where you want to check between support and oppose because you don't oppose it and you don't support it. I first of all, let me compliment Representative Belanger. I think he's bringing up a very important issue. There's something called the Families First Act, which is coming to this state. And that federal act, which we will participate in, has basically a couple goals, but one of them is preventing children from entering foster care. And the second is support for kinship caregivers. And so Families First is looking to keep more and more kids out of foster care and get them into guardianship areas and to also have them with the families. We basically support the goal of the bill. There just seem to be some issues with it, and I've discussed these with Representative Belanger. One, I think from the statistics I've seen, and I think this is right, there are about 800 adoptions a year in the state, maybe about 16 to 1,700 guardianships. You would need to give businesses quite a bit of time to ramp up to handle that many more home studies if you wanted to have home studies. So I support Representative Belanger's belief that maybe you'd have to extend this outward for a little bit. I think our biggest concern with this bill is what about the people that take on the guardianship that just don't have the money to pay for the home study? I know there have been some people that have talked about like a home study light. Doing a home study takes quite a bit of energy. You have to schedule it. You have to go out there. You have to do visits. You have to do criminal background checks. You have to do health checks. It costs $1,100 for Waypoint to do a home study with an additional 3 visits, follow-up for $750 for those 3. Say you excluded those 3 follow-up visits and just did a home study. I can't imagine you'd be able to do a home study for much less than $1,000. And I think that what that comes down to is the liability that someplace like Waypoint would be willing to take on. We wouldn't be able just to walk in for an hour and sign off and say, this is okay. So what happens to the grandmother? And I was on the grandparents committee with Senator Carson. You know, you've heard grandparents say, I took on my grandchildren, I lost my job, I lost my apartment, and I lost my partner because I've taken on my grandchildren. They lost their job because they had to take care of the kids. They lost their housing because it was a 55 and older. And some people just don't want to raise children when they're 65 or 70 years old. So my suggestion, and I made this to the representative, is I would love to see every child that goes into a guardianship have some kind of home study, but you would have to accommodate that in some kind of way for the people that couldn't afford it. And I think you're talking about a fairly significant fiscal note. If you're talking that many guardianships times $1,000, with the way that this is going towards Families First Act, and the way that it protects children, I think that's a small investment to protect the kids. I think it's the right thing to do. But I do think those are the issues we're dealing with right now. And so while the goal of the bill is correct, I think the implementation needs a little bit of work. So thank you for allowing me to testify, and I'm happy to take any questions.
Go ahead, Senator French.
And thank you for testifying. So you said there's 1,600 new guardianships created each year?
So I received a document from one of our workers that was the number they used, around 800 adoptions and significantly more guardianships. I mean, the difference between a guardianship and an adoption, as Representative Belanger knows, the difference between night and day, because a guardianship can be ended at any time. Once you're a parent, and once you adopt that child, to terminate a parent's rights is an incredibly difficult thing to do. And so that's the big difference between the two. But there are a significant number of guardians that are appointed every year between the opiate crisis, COVID, all the other things that are happening in this state. A lot of kids end up with guardianships.
And how long do these guardianships usually last on average?
I don't know the average number. They can be short. They can be incredibly long. I think Representative Belanger, how many years? Is it? Yeah, he was 3 years that he was a guardian. Some can be much shorter than that, Senator.
So you could have like 5,000 guardianships going any given year in the state?
I would have to find that number out for you, Senator. I don't know the answer to that. Yeah, I'm happy to do that. Yeah.
I'm interested in how the courts are gonna be able to review these every 6, 12, and 24 months. If there's 5,000 cases they have to take up mandated by the state.
Yeah. Thank you for the question.
Thank you.
Thank you, Mr. Chair. Thanks for taking my question. Can you remind us what is coming down from Families First in terms of support? There's going to be monetary support for kinship guardians?
Yeah, I believe, thank you for the question, Senator. I believe, I think there are a lot of things that can be done. The support, the financial support, obviously. Grandparents and relatives can be foster parents now, but they have to go through the entire system and prove that their home is as up to date as any other foster parent. So, like I said, there's significant costs to a lot of these families, and especially for the elders, they're on fixed income. And so, to all of a sudden imagine trying to figure out, whether the children can get TANF, whether they can get a SNAP program, whether all the different things, are they eligible for Medicaid under those programs? And then on top of that, having to do a study which would cost them any more, I think it just becomes prohibitive. But Families First Act is really aimed, as you said, Senator, to get the kids into the families and support them while they're there.
Great. Thank you very much. Seeing no other questions.
Thank you.
Unless there's someone else who wants to testify in 518. Going. Go on, as Senator French would say,
Nice.
at the auction.
This could be more.
much. Representative Terry, welcome. You're introducing 1431, I understand?
Yes,
Like
thank
the
you.
tie? You're looking good.
Yes, thank you.
Go for it.
Mr. Chair Pro Tem, would it be? Instead of Madam Chair?
Whatever you
Chair
want.
Pro Tem,
Just don't call me late for dinner.
sir? By way of preface for a moment, if I might, the testimony that I'm about to give in support of NH House Bill 1431 as its original sponsor is actually an abridged and updated version of the testimony I presented when the bill was originally heard in public hearing in the other body a couple of months ago. Additionally, because there were two parents' rights of bills that were introduced in the other body, leadership asked that the two sponsors actually collaborate and get behind one bill rather than two. So Representative Greeson, who will be speaking today, will be in a better position to speak by way of our arrangement with respect to emphases in this testimony today to the more detailed questions that you may have with particular provisions or items in the bill. In addition to co-sponsor Senator Guida, who will be speaking later on. So with those opening remarks by way of preface, Mr. Chair Pro Tem, honorable members of this committee, I'm Representative Paul Terry, representing Alton and Gilmanton. And I'm here this afternoon to speak to HB 1431, the bill I sponsored, that if enacted will provide New Hampshire parents with a comprehensive and consolidated enumeration of their God-given natural rights with reference to their minor children. Emphasis on comprehensive and consolidated enumeration of God-given natural rights with reference to their minor children. This particular bill is but the latest expression of a deeply rooted and treasured national legacy that has made respect for individual rights a bedrock principle and commitment of our American Republic. Indeed, as you may recall, at the very founding of our nation, we declared, quote, "We hold these truths to be self-evident that all men are created equal, that they are endowed by their Creator with certain unalienable rights," close quote. In the very next sentence, it is further declared, quote, "that to secure these rights, governments are instituted," close quote. I'm going to repeat that again. That to secure these God-given unalienable rights, governments are instituted, close quote. Throughout our history, we have striven to form what President Abraham Lincoln called a more perfect union, often doing so by enacting new laws that we have come to believe are securing more God-given or natural individual rights and freedoms. One such example of a more recently recognized and enacted law is our state's Patients' Bill of Rights and Responsibilities, a copy of which I'm holding before you in my hand. In 1981, we came to realize that we needed such a law. And I believe the time has come in 2022 to recognize that we need a Parents' Bill of Rights to make clear the will of the people of this state, that parents have certain unalienable rights with respect to the care and upbringing of their minor children, particularly and especially with respect to their educations and health care. These historic rights have been acknowledged and exercised across many cultures the world around. They have more recently come under grave threat in our country, prompting an increasing number of states to enact Parents' Bills of Rights, while others are doing so even this year. I want to thank staff at the National Council of State Legislatures staff person Emily Ronco for providing me this updated summary of what's happening in our companion states. Quote, in 2022, at least 16 states are considering legislation related to creating a Parents' Bill of Rights that would impact public education. An additional 4 states are considering modifications to their existing Parents' Bill of Rights statutes this session. Since 2019, 13 states have considered legislation addressing Parents' Bill of Rights or parental rights in the field of education. What we are seeing are states working to correct numerous gross imbalances and declare unacceptable outright expressions of obstruction and refusal to honor what once was viewed as the primary, essential, and integral role of parents in the raising of their children. Enacting the strongest version of HB 1431 will ensure that every New Hampshire parent of a minor child will enjoy the same rights regardless of county or community. It will make unnecessary a search for provisions in law that may or may not be scattered about many different RSAs. With parents encountering more and more difficulties in their attempts to provide primary guidance decisions for their children's education and medical treatment, I believe it is imperative that we act this year for them, for their children, and for all of us. It's time. So thank you for your continuing consideration of HB 1431.
Any questions? Go ahead, Senator Whitley.
Thank you, Mr. Chair, and thank you for taking my question. So I'm a mom. I have an 8-year-old. He's in public school. I care deeply about him. He's my number one priority all the time. He will always come first. And I also have a responsibility as a legislator.
I'm sorry, he loves what?
My son is my priority. That's the statement.
I'm sorry.
But I also have responsibilities as an elected official, as a legislator,
Sure.
particularly someone who has spent my career making sure that our state government protects our children and that all children grow up to be healthy and safe. So do you feel like this bill adequately balances parents' rights with the state's obligation to make sure that children are protected from, a whole host of issues?
Thank you, Senator, for that question. My wife often corrects me, and I can hear her voice right now. Just keep it simple. The answer to your question, Senator, is yes.
Thank you. Go ahead, Senator French.
Thank you, Mr. Chair, and thank you, Representative. So from reading this, I get the feeling that you feel you know better what's for your children than the state does?
Now I hear my parents. And they're saying you better answer yes.
Thank you.
But I do so without any reservation, Senator. Yes, thank you.
Thank you, Representative.
You're welcome.
I thought I read it right.
We are all set. Okay, thank you for your testimony.
Thank you very much.
Is it Jeff Greeson, the other sponsor of the bill? Is he speaking? There, Jeff. Come on down. Thank you for your testimony today.
No, thank you very much. I appreciate it. I'm losing the audience here. This is great.
Just be me and you.
All righty. Well, thank you, Mr. Chair and members of the committee. My name is Jeff Greeson. I represent Grafton County District 16. I believe Representative Terry did an excellent job in introducing the bill to you and its importance and its immediate necessity. The Supreme Courts of the United States and the state of New Hampshire have repeatedly recognized the unalienable rights of parents with respect to the care and upbringing of their children. This is not even something that should be questioned. However, these rights are being infringed upon with increasing frequency and severity. These aren't rights that government bestows upon parents. These are rights that parents have from God, and only by a compelling state interest, such as the commission of a crime, can these rights be infringed or taken away. That's the way it should be, just like any other natural right that we have. Because of the primacy of the relationship between children and their parents, it is the responsibility of the state and all of its subordinate entities to recognize, promote, and respect the authority of parents over their dependent children. See, parents are being told they should not be allowed to make decisions about their children's education. Just take a look at all the efforts to prevent the education freedom accounts, or access to curricula, or school choice. Parents are told they don't have the right to interfere with their children's decisions about their medical care. Just look at all the efforts to allow children to obtain various medical treatments without parental permission. Parents are even losing custody of their young children because they oppose the decisions made by their children, even the ones made by their barely potty-trained children. And parents are being treated as domestic terrorists for questioning anyone in a position of authority. So House Bill 1431 is an 11th hour effort to prevent the complete destruction of the family. And it sends a message to anyone who doesn't understand or might think otherwise, but children belong to their parents, not the village. And parents have the fundamental right to determine the care and upbringing of their children, and these rights are unalienable. At a time when the parents of New Hampshire are wondering where we stand, passing House Bill 1431 would say to them loud and clear that parents, we stand with you. And while the state does have an interest in protecting the well-being of the child, they do not have the right to usurp the authority of the parents, barring a compelling state interest. And so we need to make sure that there is actually that compelling state interest before anyone can act against parents. Although this bill explains the rights of parents, it is truly a bill that is for children. Thank you very much.
Well, just to give you a quick question, education freedom accounts, it's already the law. We've already given you that. School choice you have under education freedom accounts, maybe going further. We passed the non-discrimination in the trailer bill last year. Are you going to get anything more out of this, or have you already won?
Well, look at the opposition to all of it, because we just went through a whole bunch of bills over on the other side there, trying to undo everything that was just done. Take away the education freedom accounts, take away school choice. There are people who will oppose this bill because they loathe homeschooling. So there is opposition, and if we don't put this in writing right now, they'll take it all away.
Thank you. Go ahead, Senator French.
Thank you, Mr. Chair, and thank you, Representative. Does this bill in any way limit parental rights to what's contained within the bill?
I'm sorry, does it limit the rights to the, in broad sense, no, sir. It doesn't limit it to just these rights. It's like we have the life, liberty, and the pursuit of happiness. And what is that? And so, and it's more than just those three things. It goes beyond just those things. We found the right to privacy and the penumbra of, so we have rights that are inalienable, and you could not possibly outline every single one of them, because then it would just be limited to those things. And so as we see and declare that things are not the way they should be, we can go in and say that is an infringement upon a right. And so we now declare that this is a right that you have, and you can't infringe upon that. So this is not this is a finite list of rights, but this sets the bar.
Okay, thank you.
We're all set. Thank you very much for your
Thank you,
testimony.
sir. Appreciate it.
Don't bother looking that way, just look here.
I'll just look, I always look to, I guess, no, I look to my right usually. But
Yeah.
doesn't sound good left. Senator Guida, is he in the hallway? I know he wanted to testify. No? My friend Josh Yakalis here. Come on down. Oh, sorry. We got a little system here and a seniority thing. Senator Guida, how you doing today? Good to see you, my friend.
Thank you, Mr. Chairman, members of the committee. For the record, Senator Bob Guida, District 2. And I'm here today to testify in support of this legislation, but to offer an amendment for the committee's consideration. And I'd be delighted to have our assistant, let me keep that. Parental rights is an area that is critical to the success and the future of our entire society. When one looks at what has happened over time, the family structure has been brutalized, and broken families produce broken children. And we, as senators and the House and the governor, are dealing with the consequences of those broken homes with wraparounds and psychological counseling and all these things that we're putting in place. Okay. All of which have never been around before, and in their inception now present new challenges, okay, to informed parenthood. Schools are administering drugs, schools are advising on counseling and so forth. And so the amendment I've presented to you restores a critical component that was removed from the bill as amended by the House. That is the parental rights over medical decisions. My amendment specifically addresses that because of such things as gender dystrophia, those types of issues where they are coming home to school, potentially treatments through schools. Okay, this amendment clearly stipulates the rights of parents. It also stipulates what I will admit are somewhat severe penalties, more severe than the amended version from the House. And I'd be willing to negotiate those, but I don't think we can negotiate away the rights of parents to have absolute authority, except as this amendment, my amendment states, in those cases where the law has intervened for a reason, okay, over all medical decisions about their children, okay? I have 3 grown children. We homeschooled our kids. We had absolute control over everything, their education. They're all college ed graduates, 2 of them have master's degrees. They're all productive citizens. Okay, but I would never, as a parent, and I would submit that you would not either, allow a government institution to make a decision about your child's medical care that you are not aware of. Now, there will be those who may say that other aspects of the law and other provisions might cover it. This Bill of Rights does the very same thing that the Patient's Bill of Rights did. It takes and makes very clear in one place all the rights that are God-given rights to parents in those instances where those rights may be jeopardized by an overzealous state, either intentionally or unintentionally. So for that reason, I would offer this amendment, 1322S, and ask for your consideration of that to restore the proviso that parents have the absolute in statute right over the medical care of their children. Thank you, Mr. Chairman.
Thank you, Senator Guida. French, all set? Very good, clear, concise, good job. Thank you, Senator. Representative Fiocala, come on back down. Sorry about that.
Thank you. Oh, it's good that I went after. So I'm on, thank you, Chair and members of the committee. For the record, my name is Joshua Fiocala. I'm representing Fremont and Brentwood and Danville and Rockingham 33. I am on Children and Family, and I was the one that drafted the amendment that made the, in consultation with some of the other people on my committee, with the amendment that you see before the language as amended by the House. And the amendment proposed by the senator is essentially replacing the language back to what it was originally in the House. And so this gives me a little bit of the opportunity to talk about why those changes were made and that there would not be enough support to pass the bill in the House in our committee, at least, whether or not the whole House agrees, for the bill as amended with this proposed amendment. There was a question earlier about whether or not this is a limited list of rights that was made. And on the first page of the amendment, or of the bill, line 26 and 27 says that it's included but not limited to these specific rights. And then there's also a question of, is this giving us something new? Or is all of this really already in law? And a lot of it is in law as far as the rights of the parents. This legislation kind of brings all of those pointers in different places into one spot that a parent could look at and say, hey, this is, I need to go look up in this part of the law, or I have this right here somewhere in law. But then it does do additional things. Some of the things that it does is it says that each school should make a policy as far as educating the parents on their rights and exercising them. And then it also explicitly states that there is a bunch of things that parents have the right to get information about, and that they need to request that of the superintendent. And if they don't get a satisfactory answer, then they go to the school board and then go to Superior Court if they feel that the questions have not been answered. And then there's also some language that, as far as, especially on page 2, that is new, as far as line 6 through 10 about notifying promptly if you think that a crime has been committed against your kid, that they let the parents know that a crime has potentially been committed against the kids as soon as possible, as long as it wouldn't impede the investigation. Also, as far as on page 2, lines 11 through 16, the limiting, encouraging or coercing, or attempts to encourage or coerce the minor from withholding information from their parent, unless that parent is, it would impede a criminal investigation, or the parent is suspected of committing a crime against that kid. So you're not trying to put the state in between the children and the parents. That's what, these things are some new stuff that is not currently on the books, right? And then there is also, so there is some violations or some punishments down on page 4 that are different than is in this current, in the original bill, and as the amendment proposes. We changed the penalty from for some of those other things that are not getting appealed through the process to, as far as records requests. But if you attempted to coerce the child to not tell the parents something, you might be in violation of this stuff, and this would be applying to you. And we changed it from a Class A misdemeanor, which could lead to jail time, to a Class B misdemeanor, which would not. And we also changed from a teacher losing their license to just a reprimand going in their permanent record. Obviously, reducing the staff, like let's say theoretically mid-school year, may create significant hardships on that school district. And if there's no, if the only crime is, encouraging a kid to not tell their parents something. You may just have some corrective action that you don't need to have that teacher be out of the classroom for a full year. So in addition to that, there are a bunch of things that were opening up kind of a can of worms as far as the medical information that was stripped out of in the House version, because the can of worms got into some into something that I think was too much really for the committee to get on board with, and needed a lot more time to be able to hash out that the wording that would be appropriate, especially if you're talking about, what if the parent is an abuser, or the parent is harming them in some way? Do they have special rights to be able to get the medical records of those kids? Stuff like that. It opened up a can of worms that the committee thought that it would be better to pass some part of this instead of saying that we wouldn't be able to fix it and come to an agreement on the language. And so I think that that mostly address some of the concerns, and I would caution the committee that it did only pass Children and Family with a 7-8 vote, and so I feel like this was a good compromise that got it to even pass the committee, and I would caution going back to the original language.
Thank you, Representative. Senator French, you also had a question. Your light's on, so.
Yeah, no, I do have a question. Thank you, Mr. Chair. So you spoke to the amendment, speaking to the original, the bill that we got through the House. If that amendment did not fly, are you in support of this as written?
Thank you for the question. So yes, this was the amended version that the senator just gave is going back to the original language of the bill. So I voted to support this bill as amended by the House. Absolutely, I support it. And
I would like to see.
I would like to see this bill as amended by the House to be supported by the Senate. Absolutely.
Thank you.
Thank you.
Thank you very much for your testimony.
Absolutely.
Senator Gatta, you want to clean up? Hey, can you give him a second? I can.
Thank you, Mr. Chair, and
Giving you
thank you, members of the
second,
committee. Well, you just heard is balderdash. Okay. Since when did expediency ever override principle, and especially in the care and nurturing of our children by their God-given parents? The House's version of the bill does not stipulate rights. It stipulates, let's have a committee meeting to figure out what the school is going to give. It completely strips out medical concerns, which are extremely important and of growing importance as our society continues to evolve. Parental rights are absolute rights. They're not subject to supplication of parents to boards. Those are God-given rights, and we have the obligation to protect those parents and those children. Regarding the conflict and the can of worms, I would invite your attention. Line 25 on page 3, on the Roman 3 on page 1. Compelling state interest shall mean a circumstance of such a grave nature that state must act in order to protect the rights or life of a child over the rights of that child's parents. That exception is in my amendment. As a Senate, okay, we must protect the children. We must protect the rights of the parents to whom the Almighty gave those children as the first authority, and other than in exceptional circumstances which are stipulated within this amendment, in every instance. Thank you, Mr. Chairman.
Thank you, Senator Gatta. Representative Don Johnson. Hi, Ms. Johnson. How you doing today?
Good, how are you?
Could not be better.
Representative Don Johnson from Laconia. I'm a co-sponsor on this bill. I just wanted to come up, everybody before me, we've worked really hard in getting this Parents' Bill of Rights because it's needed. As a parent of two teenage daughters myself right now, I have seen, and I also sit on the school board, I have seen firsthand some of this stuff happening. Our kids need their parents. They don't need teachers and staff telling them, don't talk to your parents, you can't do this. The parents have a right to know what's happening in our kids' lives. We can't help them if we don't know there's a problem. And when a teacher or staff or anybody else says, don't tell your parents, we'll be your parents, we'll help you, I find that offensive and outrageous. There's many issues that have happened. I just wanted to let everybody know where I stand. I support this bill. I support the amendment wholeheartedly. And I do not want to see any medical advice given by any school district or anybody else but a parent and their doctor.
Thank you. Do you have any questions? Thank you. I have 3 teenage daughters too, so I understand. I don't know how you stand. You must be tired.
Patience and love.
There you go.
And
Thank you
walk
very
away
much.
sometimes.
Thanks for your testimony. Jay, are you still here? Come on down.
Thank you, Senator. For the record, J.R. Hull, former state rep from Bowen Dunbarton, now back as a private citizen. I would like to speak on behalf of House Bill 1431. At this time, I cannot comment relative to the amendment as proposed by Senator Gaida or the bill that passed by the House. I can, in fact, though, testify that this is a baby step. Our Constitution is where we capture most of the rights of our citizens. I would argue that this needs to go further than statute, but statute is the first baby step that needs to be taken now. Long term, we need to put something similar to this in statute. I have, when I was a state house member, proposed a bill that would have been Article 2B, which would now be 2C if it was enacted today, because 2B has been taken by the right of privacy, to make sure that children have parents as their first legal advocate for their behalf and not the state. Senator Frentz asked a good question, right, about parents knowing better than the state. Thank you. It's a good question. Parents live with their children effectively 24/7. They can detect subtle changes in personality. They can detect subtle changes in eating habits. They can detect subtle changes when it comes to how their children relate to other children. The state is not going to be cognizant of those subtle changes, which in fact are important to determining what is in the best interest of the child. I've spent the better part of the last 3 months defending my family against the state. Trust me, I speak from experience. Parents are held, when they choose to educate their children, to a much higher standard than the state. There's a separate bill going through Senate Education relative to what the children need to do in terms of a standardized assessment, okay, to be allowed to be homeschooled. That standard doesn't exist in the state, doesn't exist in the DOE laws anywhere, but yet homeschool parents are held to a higher standard. I could speak to a number of things about this bill, but this is the first of many important steps that needs to take place to make sure children are protected by their parents. Their parents who, as you mentioned before, you have children as well, right? Or a child, I wasn't sure, I wasn't counting the number you mentioned. Parents love their children. No state employee will have the same passion to protect the child that the parent does. With that, I'll end my testimony. Take any questions.
Thank you. Any questions? Thank you, Mr. Hall. I skipped one person, Rep. Alicia Lekas, because you didn't check if you wanted to speak or not. If you do? You do not. Okay, thank you. Maura O'Neill? Hi, Miss O'Neill. How you doing today?
Good afternoon.
Mr. Chair, members of the committee. For the record, my name is Moira O'Neill. I'm the child advocate for the state of New Hampshire for a day or two more. The Office of the Child Advocate, as you know, is an independent agency mandated to provide oversight of state and state-arranged services to children and to promote children's best interests. I appreciate the opportunity to speak today in opposition of House Bill 1431, establishing the Parental Bill of Rights. I have provided you with a lengthy testimony, and in the interest of time, I'm just going to go over a few important points today. We oppose the bill for several reasons. Although we do agree and we respect parents' fundamental rights, we have a statutory duty to protect and to promote the rights of children. HB 1431 proposes statutory language that is vague, it is broad, and on some points it's redundant to existing laws and practices. It further provides no accountability or responsibility on the part of parents for their own actions. A review of some of the language demonstrates confusion in the role on the state and the obligation to children, with potential for great unintended consequences on children. So I'll just go through the amendment, or rather the bill as amended that we saw originally. I don't see as much in the amendment that requires my commenting today, and since that hasn't been deliberated upon, I'll stick with that. And you can carry over any points that you think are relevant. So on page 1, line 1, in the Declaration and Purpose, it notes that parents' fundamental right to direct upbringing, education, and care of their minor child. We do not disagree. However, the fact of stating rights already constitutionally protected or in statute or practice communicates an intention of a higher level right to the exclusion of children's rights or those of the general public. In page 1, line 16, Senator Guida's amendment does speak somewhat to the notion of the state's or a compelling state interest upon which it may act. And we just want to clarify that under the legal doctrine of parens patriae, it is the child's interest upon which the state acts, not the state's interest. Unfortunately, there are times when parents are unable or unwilling to keep their children free from harm. If the state, a proxy for the community or the extended family, takes no action, would we leave children in harm's way? To illustrate this point, refer you to the Harmony Montgomery case that we are all worried about today. Although the Office of the Child Advocate takes no position on the father's culpability until that case is properly prosecuted, we do note the outrage expressed by members of the public, including the governor, about 2 states who have entrusted the girl's care to her father. As written, House Bill 1431 would honor the father's rights to direct her care and upbringing, and it could disallow Child Protective Services from intervening on her behalf. Page 2, line 11 through 16, the new section 169I4 in section 2, it threatens disciplinary action of school staff who receive confidential information from children. While there is exception for criminal matters, there is no exception for potential abuse or neglect. The Office of the Child Advocate has seen a disturbing number of children whose parents have threatened, beaten, and thrown out of their homes when they have disclosed personal information about themselves to unaccepting parents. Given that schools are where children spend the majority of their waking hours, it's also, for many, the only place to find a safe person to speak to about personal concerns. Without that safety net, we fear what the outcome will be for many children. On page 2, at line 20, it states the rights of a parent of a minor child in this state may not be limited or denied. Although the line is qualified by unless required by law, the sentiment risks conflict with children's rights and could be interpreted to nullify the rights of a child, in some circumstances, potentially affecting his or her safety, well-being, access to care and education, among other things. On page 2, at line 22 to page 3, line 18, section 169I5, Parental Rights in Education, lays out a set of rights, several of which are already codified or are typically communicated through established means such as parent-teacher conferences and school websites. Some of the rights proposed, however, come with a level of burden that could interfere with teachers' capacity to teach or might position parents to make ill-informed decisions. For example, on page 3, line 1, the right to object to instructional materials or other materials places no criteria upon which the objections may be based. On page 3, line 5, allows for parents to exempt children from immunizations. The basis for this option already exists under RSA 141C20A. However, because immunizations for infectious diseases are a matter of public health and prevent the spread of diseases that can be disabling and deadly, these kinds of decisions should be well informed. We would suggest parents asserting this right should be provided information about both the benefits and risks of all immunizations to inform their decision. On page 3, line 19 and 2 would allow parents to request information under RSA 91A. This right is reasonable and exists, but to ensure this right is complied with, it would be fair for the state to provide schools with the legal support to respond to 91A requests that can monopolize staff time and divert resources from essential tasks of education. On page 3, line 34 to page 4, line 5, proposed 169I6 exceptions lays out what the chapter would not authorize. Page 3, line 36, the chapter does not authorize a parent to abuse or neglect a child. However, the bill appears to have stripped child protection services from investigating and intervening. Page 4, line 1B, this chapter does not prohibit officials responsible for child welfare from acting pursuant to RSA 186.11, section 9C. However, 186.11, section 9C actually governs the duties of the State Board of Education on adopting policy around exceptions to course materials by parent objections. It does not apply to child protection. Page 4, line 623, proposed 169I7 provides for mechanisms for parents to appeal in Superior Court and cause disciplinary action on school staff. The section does not include any accountability of parents to act lawfully and with reason, nor does it provide for punishment for those who would use the chapter to harass, intimidate, or act with malicious intent towards school staff. So finally, it's painfully apparent that House Bill 1431 makes no reference to the interests of children. This we find disturbing as potentially a means for lawful abuse and neglect. Additionally, parents already have strongly established rights in New Hampshire. Being a parent, however, is a privilege, it's a gift, and it's a grave responsibility. This chapter would pit parents' interests against that of children under 169C2, where the best interests of the child shall be the primary consideration of the court in all proceedings under that chapter. Proponents of this bill are challenged to separate their objections to the state as being from children, or who are vulnerable, without voice, to call for protection of their own rights. It's certainly in the interest of children for schools and the state and parents to work together to ensure their well-being in all domains of their lives. State and local authorities may not always be correct. However, we had no reason to believe that all parents will have the expertise or understanding of children, child development, pedagogy, or healthcare to make all the right decisions without the assistance of experts. For these reasons, we urge the committee to find HB 1431 establishing Parental Bill of Rights inexpedient to legislate. And I'll stop there and take questions if you have them.
Thank you, Ms. O'Neill. Go ahead, Senator Whitley.
Thank you, Mr. Chair. Thanks for taking my question. Over the past decade, we as a state have been working to rebuild our child protection system. You know this because the very existence of your office was out of that work. You know, I know this as an advocate who has also spent years trying to protect children and make sure that every child has the ability to grow up healthy and safe. You know, again, I view this bill in the lens of a parent who cares deeply for my children and all children, and I understand deeply the rights of parents. And I also feel like, you know, should we move forward with this bill, it would be taking us backwards in the really significant work the state has done to prevent any child from being abused and neglected. And also in many cases, we have really horrifying cases of child deaths. Do you agree that this would take us backwards in that work?
Thank you for that question, Senator. I do agree. I have to say that I can't imagine that the sponsors of this bill aren't dedicated, determined, and loving parents. The problem is that the way the language is presented in this bill, it can be interpreted and implemented in a way that undermines any child protection.
Thank you.
Thank you very much for your testimony. You're awesome.
Thank you.
Brian Hawkins. Been a while. Good to see you.
Good to see you. Good to see you too, Mr. Chairman. Thank you very much. For the record, Brian Hawkins here today representing NEA New Hampshire. We have the honor of representing over 17,000 educators across the state who have gone through extraordinary lengths over the last couple of years to meet the countless challenges, especially this pandemic has presented, to carry out what matters to them most, which is our students. And today I'm here in opposition to HB 1431. We have several specific concerns about this legislation. And I'll start with the first and foremost, which is the stated penalties at the end of the bill. We think that in addition to that, we think that some of the language is overly broad, and that overly broad language is tied to violations in the proposed chapter. And I think it has been noted already, there are numerous areas where some of the language is confusing or duplicative and already existing in law. So again, first, in the final section of the bill that outlines the series of penalties, the bill states that any person who violates any provision of the chapter shall be guilty of a Class B misdemeanor. Violations of bill, the makeup of a lot of this bill resulting in a Class B misdemeanor, we feel is just over the top. It's too much. And really having this in there only serves to contribute to a climate of fear and intimidation for school employees. And I think, especially in light of what has happened over the last couple of years, we don't think that this would be a good climate, a good addition to the climate in schools. You know, we're seeing, as a result of some of the laws that have been passed, and we have teacher bounties that are out there, and things of that nature. And so adding a criminal penalty into this bill, we think is too much. Criminal penalties also just ensure that, you know, you're going to have insurance costs that will need to increase. And for some of the record requests that they're talking about, we'll probably just make them more complicated and more time consuming, not less so, which is, I think, what some of the sponsors of this legislation and some of the legislation that we saw passed in the House Education Committee were seeking to do. So we think that this would actually be counter to that. The proposed penalties are particularly problematic given that the provisions of this bill are so broad. So for example, in the second section of 1431, in the proposed 169I4, that all parental rights are reserved, and it goes on, including but not limited to. So this leaves open that there are other rights or violations that could happen, which would then cause the person who has violated those rights to be criminally prosecuted. Although we don't know what those unstated rights are, And therefore, I think that goes to the vagueness and why this, particularly when you associate and couple it with the violations at the end. Also on the violation, it seems to set up a parallel violation procedure, namely in 169 I-7 Roman 3, it states that any teacher, school employee, or administrator that violates any provision of this chapter shall have a disciplinary letter added to their personnel file. So at least in the way we read this, it's unclear who is the deciding entity here as to whether there is a violation that would constitute that. Is it the superintendent? Is it a court? If the superintendent or the school board says that there is a violation, but the Superior Court says that there wasn't, how does that work? Vice versa. Does the disciplinary letter still go into the personnel file if there's a disagreement there? And also, it also seems to insert itself into what is a disciplinary process that takes place at the local level, which is really established at the local level and also negotiated items. So 91A already has procedures in place if documents aren't disclosed in a timely manner. So we think that that is confusing. It seems to set up another parallel procedure with the court. So which, sort of which one takes precedence there. We also think that there are several parts of this bill that leave a lot of questions, contradict existing laws and education rules. I think that's been cited already, and I'll have that included in the written testimony that I submit. There's also a side-by-side, I think, that was done in the House to present some of that information as well. The first couple of provisions listed in the rights about directing the education of a minor child and directing the upbringing and moral religious training of his or her minor child. How does this interact with the rights of other parents in the class? How granular does this get in terms of the right to direct, or are we talking the right to go to a public school or private school or EFA or whatever it is? So that would be a whole nother story, but I think it seems a little broad as to how granular are we getting in the classroom. So finally, with respect to the information on instructional materials and provisions outlined in the bill, again, this is a situation where I think a lot of the language is duplicative. We already have RSA 18611 that states that a school district shall supply curriculum course material to parents and guardians, and so that already exists there. It's unclear as to whether this bill is asking for something more than that or more than what's already in 91A. And I'll just say, in my short time at NE New Hampshire, any educator that I've met, if there is a request of a parent to look at instructional material or curriculum, if it's not already provided to them, they are more than willing and want to do that, because I think, parents and teachers working together ultimately is going to provide some of the best success for our children. So I think that relationship there already exists, and so I think some of this is unnecessary and not needed in this bill. I'll have more that I'll include in my written. I'll stop there. Happy to take any questions.
Sure. We're all set. Thank you.
All right. Thank you. Good to see you again.
Appreciate it. Good to see you, sir. Keith Cunning, come back. Been seeing you all day, haven't I? Weren't you here in the morning?
No, it was up in Children and Family Law. Members of the committee, for the record, my name is Keith Kinning. I'm the advocacy director at Waypoint. I've been there for 10 years, and I would have to say the thing that has surprised me over the last 10 years is what parents can do to their children. It is chilling. It is chilling what some parents do to their children. They slam them against walls. They break their arms. They try to starve them to death. They throw them out windows, and they murder them. They murder their children. You know, I carry this around. I've carried it around. These are the pictures of some of the 25 kids that have died in the state over a 10-year period. This was part of the Fatal Flaws series done by the Concord Monitor. And I just want you to think about this as you're debating this bill, is what you do for one parent, you do for all parents. And I am sure the parents in this room, I know they're here, they care about their kids, they love their kids, they want to be involved in their education. But you know, just in the last year or so, think of the names of Sadie Willett, Brielle Gage, she's no longer here, Elijah Lewis, you know, and now Harmony Montgomery. In our heads, we want her to be alive, but I think most of us think in our hearts there's something really bad that's happened there. So I would fundamentally disagree that parents have absolute rights over their children. Children are not chattel. Children are children, and children have rights. And one of their rights is the right to life and liberty and happiness. And I ask, when you start looking at such broad language, what is this language going to do to the parents, not that love their children, but the protections, the extra protections this is going to do for parents that treat their children like this. And there are parents that groom their children for sexual abuse. These are not easy things to talk about. It in some ways has destroyed me over the past 10 years to find out that parents can treat their children this way. But I ask you, as you look at this language, to not ask yourself just how this is going to impact the parents that love their children, but how about the parents that do these kind of things to their children? And are we expanding their rights in some kind of way? And if we are, then I would say that this bill has serious flaws in it, and Waypoint opposes this bill. So thank you for the time. I just wanted to point out and ask you to hold that in context as you make your decisions.
Thank you very much for your testimony, Mr. King. Are there any questions from the committee? Seeing none, thank you. The chair will call Deborah Howe.
Good afternoon. For the record, I'm Deborah Howes, president of AFT New Hampshire. I represent 3,500 teachers, paraprofessionals, school staff, public employees, and university personnel in New Hampshire. And I've prepared written testimony that I'm sending around, but I will summarize so as not to repeat what's already been said. I'm here to express the concerns my members have with HB 1431. We, as educators, we know that students do best when parents and educators are working as a team to support students in their learning. We value parent involvement, and anything that encourages that in a positive way is something that we desire, we seek out, and we want that to be a positive thing. But what we see in this bill will not do that. There are some things in here we like. We do like the provisions that would have districts have a plan to promote parental involvement, facilitate parents learning more about district-approved curriculum and their child's general course of study, and ensure that each district give parents full information about gifted education and special education programs in the district. Those are all positive things we would like to see. But we do have concerns with how sweeping this bill is. And, asserting that parents have an absolute right without obstruction or interference to direct the education of their students causes us concerns, particularly when you're talking about public school. Where does one parent's rights to direct his or her child's education come against the boundary of another parent's rights or against the school's obligation to provide an education for all students, particularly when you pair that with the section on objectionable materials and what happens when one parent objects to part of a lesson How much do you have to stop and redo a lesson? How much time do you take away from the students you have in front of you because a parent objects to part of a lesson? It becomes quite a task to try and make sure that you are educating all the students in what you need to teach them and still meeting the desires of each of those parents to direct the education of their child. We also object to the portions of this that would allow for punishment of teachers with disciplinary notes in their files. That does not encourage any sort of collaborative spirit or two-way communication if you're always looking over your shoulder to see if someone's going to be punishing you because you haven't produced documents in a timely fashion. We think that this will pit parents against each other if you have disagreements on how you want your child to be educated versus how another parent wants their child to be educated, and it will depend upon which parent can be the loudest in advocating for their child. That's not how we want to see our schools run. Those sort of policy agreements should be worked out at a school board, not in the classroom. Anyway, but I urge you to vote no on HB 1431 because ultimately this bill will not help teachers teach or students learn. It will just see more division in our communities and will invite further political interference in our classrooms, and I hope you will ITL this bill. Thank you.
Thank you very much for your testimony, Ms. House. Are there any questions from the committee? Seeing none, thank you. The chair will call Representative DeSimone.
Thank you, Madam Chair and committee members. I really wasn't going to testify. I know you've had a long, hard day. When you deliberate over this bill, I would just ask you to take into consideration the aspect that most of us are good parents and we care deeply about our children, but we have all too many parents out there who don't. They don't care about their children and they don't treat their children with the due respect that children deserve. They beat them, they're horrible to them, they take them into bathrooms and they do horrible things to them. Not all parents are good parents. And when you talk about in the bill that both parents should be able to go to the school and have parent-teachers conferences, what if one of those parents has a restraining order? They shouldn't be in that room with the child and the mother or the child and the father. What if another of those parents is a pedophile? They shouldn't be near the school. I think that this bill, as amended by the Children and Family Law Committee, is a better bill than the bill that was originally handed to us. I just ask you to understand that we did the best we could do with a bill that had many, many, many flaws. I understand what the authors of the bill were headed toward, but I don't think that this is the solution to the problem. Thank you very, very much for your time.
Thank you very much, Representative. Are there any questions from the committee? Seeing none, thank you. The chair will call John DeJoy.
Thank you, Madam Chair, members of the committee. For the record, my name is John DeJoy. I am here today representing the New Hampshire chapter of the National Association of Social Workers. The NASW New Hampshire is a membership organization for social workers representing a variety of specialties. Within that field, we represent more than 700 social workers currently and growing every day, I can happily say. I rise today in opposition to House Bill 1431. While there are many areas that I could speak to, I'm going to confine my remarks to a section on page 2, Roman 2, lines 11 through 16, that is of particular concern to social workers. Teachers as well, but I'm speaking for social workers. This section makes it a violation for any of the listed folks, including school social workers in particular, to encourage or coerce or attempt to encourage or coerce a minor child to withhold information from their parents, and it makes it, it goes on. Unfortunately, and any of us who are parents know this, there are times when our children don't feel comfortable talking to us for any number of reasons, sometimes serious, sometimes minor. Children often turn to teachers, but also to school social workers, to talk about a fight they have with a brother or sister or their parent. More seriously, they may talk about drug dependence. And in the most grave of circumstances, it is not uncommon, unfortunately, for students to speak with school social workers about suicidal ideation or worse, attempts at suicide. What this bill will do is have a chilling effect on the conversations and the comfort of children in speaking with a trusted adult. Far from encouraging students not to tell their parents, social workers will encourage the students to speak with their parents. But these are difficult things for students, for anyone, but particularly for children to talk with their parents about. What this bill sets up is a situation where a parent can allege that the social worker advised the child to withhold information without evidence. There is no due process provision in this. There is no description of who's the final arbiter of whether this did or did not happen. But it does classify as a Class B misdemeanor. It allows the parents in the violations section to file damages. In short, it could destroy the career of a social worker based on allegations and innuendo. There are mechanisms in place should any social worker collude with a child to keep the parents out of decision-making. That's what the Board of Mental Health Practice exists for. That is an unethical practice in the practice of social work. But this bill will prevent children from having a trusted adult to speak to and could result in more dire consequences for these children. For those reasons and many, many others, the NASW New Hampshire opposes this bill and would ask you to kill the bill.
Thank you very much for your testimony, Mr. DeJoy. Are there questions? Senator French.
Just one, thank you, Madam Chair. Just to go over Section 2 that you just went over, I don't read it the same way you do. Am I reading it wrong? It says they will not intend to encourage or coerce a minor child to withhold information. It doesn't say what you're saying, that it that they can't withhold information. So if a child is talking to someone in the school or an official in confidence, it doesn't say that that person who received the confidence information has to report it to the parents, does it?
No, it does not.
Okay, so where's your problem with this? I don't understand your problem with that section, I guess.
We do have a slightly different reading, Senator. I don't know which one is correct, but the concern is that there is confidence in mental health practice. This does not disturb that directly. The concern is that there is a parent who becomes aware can file an allegation of complicity with the social worker. There is no call in here for any evidence or any judgment on what it takes to reach that bar. We don't have any standard of proceedings. So the innuendo in and of itself, based on this language, could find the social worker guilty of withholding information, even though there was no data to support that. That's the concern. So what professionals will do to protect themselves is stop having these conversations. That's the danger, because then we leave children conceivably without any trusted adult to speak to.
Senator Khan.
Thank you, thank you, Madam Chair. Thanks for your testimony today. On page 2, you pointed to line 11. Now, I want to point you to line 6 through 10. And,
Okay.
and it's also in the amendment that I see here. Just it's on page 3 then. The point here is that, and I think this was made by some of the school advocates, child advocates as well. As I understand the procedure, schools are not social work institutions. They do not do case management of households and parenting. They observe changes in a child or conditions that cause them to have concern for the child's welfare. And their responsibility is to report that. That's a statutory responsibility. If you see it, report it. This seems to say you can't do that without informing the parent first, or informing the parent in that process. The school is not taking on a complaint against the parent at that point. All that they're doing is communicating a concern, reporting that to Child and Youth and Family Services, for them to follow up it for voluntary assistance or evaluation by that agency of that household. Is that correct?
All adults in the state of New Hampshire, and particularly social workers and other mental health professionals, are mandated reporters. And any suspicion of abuse and neglect must be reported to DCYF. Absolutely true. What is also true, Senator, is that across the state, school districts operate very differently vis-a-vis social workers. Social workers in schools do not provide individual therapy, but many social workers do provide casework for families or children. Many social workers do provide referrals if a child wants assistance with drug abuse. They certainly can provide the child with referrals. They provide a number of, they teach in schools. So social workers have a very broad mandate, and it's varied from school to school. What doesn't change is that, yes, we are in fact mandated reporters, and if we have suspicion of abuse and neglect, we are required to report that to DCYF.
And if I might follow.
Yes, follow.
And a teacher has that same responsibility, correct?
Absolutely. In fact, every adult in the state of New Hampshire is a mandated reporter.
I guess we should be including all adults in here. Thank you.
Are there any further questions? It's seeing none. Thank you very much, Mr. DeJoy. The chair will call Anne Marie Banfield.
Good afternoon. Good afternoon, Senate Judiciary Committee. My name is Anne Marie Banfield for the record. I'm a parental rights advocate in New Hampshire, primarily focused on academic excellence in education. I urge you to vote ought to pass on HB 1431. I've been working as a parental rights advocate in New Hampshire for about 20 years. I think it's important to mention that in all that time, I've never received a dime in compensation. My focus on academic excellence in education, and so much of my time has been spent before the Senate Education Committee in front of Senator Khan. Parents who struggle to be a voice for their children oftentimes run into lobbying organizations that are well-funded and hire high-priced attorneys to fight against them. The irony is that those organizations and individuals are paid out of the school budget through dues. So in essence, parents pay the salaries of those attorneys and lobbyists who are hired to fight against them. I would assume that some of them will probably oppose this legislation. I want to make it clear that I have no financial stake in advocating anything on behalf of parents. I do it because it's the right thing to do. School administrators have high-priced legal teams that can be extremely intimidating to parents, not to mention that they are there to protect the school system. The balance of power has been against parents for many years. Even if parents have a good case, the legal cost to them versus the superintendent who can use taxpayer-funded attorneys results in parents giving up. That normally leads to parents to find an alternative school system. Now you know where school choice push comes from. Public school enrollment declines, private schools and homeschool numbers increase. A parental Bill of Rights would help shift some of that power back to parents. I've seen parents lose court cases after their children were assaulted in school, Manchester being one of them. Parents have been denied access to their child's classroom to observe. It is extremely rare that I get a parent who wants to observe their classroom, but when it happens, it's because they want to find ways to help their children and the teacher figure out how to work together to benefit that child. In one case many years ago, I had to turn to former state senator Peter Bragdon, who had also served on the school board in his town. He managed to facilitate a father's request to observe his child's classroom. I shouldn't have to turn to a state senator in our school in order to pull some strings so that a father can go in, a good father, go in and observe his child's classroom. But that's what it took. Public schools are public, and transparency builds trust. But in some instances, good parents are running into roadblocks. That is true. Everything should be made transparent unless there is a legal reason via due process to keep a student's personal information private. From the curriculum to the materials to the classroom, nothing should be hidden from parents. Some administrators have been forthcoming on information I've requested through 91 right to know requests. However, others have put up roadblocks and refused to provide information I've requested. There's a pending case in SAU 16 that I'm sure that you're aware of. I'm assuming you received the email, where a resident requested documentation from the superintendent, and some of that documentation was not provided to him. I've been in the same situation. It looks like that's going to end up in the Supreme Court. Even if there are provisions in federal law, I found that having language in state law does help. It helps parents access information. Loopholes exist in federal laws that have been exploited, and that is why we needed a state law on parental consent for non-academic surveys. The Federal Protection of Pupil Rights Amendment Act should have required parental consent on student surveys when schools administered them. But administrators found a little loophole that it said if these surveys were voluntary, they didn't have to get parental consent. Well, children, you put a survey in front of them, they think it's a test. So they took it, and parents had no idea. And what happens? Parents erupt when they find out what their kids were asked on these invasive surveys. So in this case, the state statute helped. So if there's something in federal law, having something in state statute does help parents access information. As enrollment continues to drop in New Hampshire schools, and it is, and there are various reasons for this trend, I also believe that if parents have some fundamental rights to exercise, they will be more likely to keep their kids in the public schools. If they leave, they take a portion of the funding that was going to their public school. What you're basically doing is having angry parents walk away. So not only will this Bill of Rights for parents help parents, it will help them keep their kids in public schools. I have seen this. When parents can access this information, it eases their mind sometimes. So that's a good thing. For these reasons, I do ask you to ought to pass. I just want to bring up a couple things that were brought up in terms of the kind of work that will be entailed by schools to provide this information. I can tell you that when I was in Bedford, I asked the superintendent to post a check registry online on the school website. You can go to the school website right now, pull up the check registry online, and look at every expenditure from the school. cuts down on right to know requests. This actually helps when they make things transparent, when they post competencies online, like I believe they used to years ago and they no longer do. If they post these things where parents can access this information, then it won't take right to know requests and the teacher accessing. Yes, it's going to take some work, but parents have a right to see what's being taught to their kids. I found some of the testimony almost pitting kids against parents, and almost like all parents are, there's something called due process. We're hearing about abusive parents. Nobody who wants this bill passed would want to in any way support an abusive or a neglectful parent. That's the last thing I would ever want. My gosh, I mean, but there was nothing in terms of due process. We're talking about parents that should be able to look at curriculum. I mean, this is not something that, I want to enable an abusive parent. Finally, I just want to bring up one thing. Child psychologists who work in private practice have to follow the APA Code of Ethics. And within that code of ethics, they have to inform parents along the way. They have to be informed parents of assessments. If they're going to assess a child, parents get to see this. And if they don't, they lose their license. Since when do we not have the same kind of expectations for the people who teach our kids? And if there are abusive or neglectful parents, let them go through the due process to prove it. But the rest of us should be able to access this information. So I don't want to take up any more of your time. I will send this to you via email. My toner went out this morning, so I couldn't make a copy, but I thank you for your time very much.
Thank you very much for your testimony. Are there any questions? Senator Khan.
Thank you, Madam Chair. Ms. Banfield, I saw you this morning. Probably see you later this week, too.
Possibly.
We've got a bill on education, and I'm trying to remember the number, and the numbers are just, there are too many of them this week. It's driving me nuts. But there is, relative to curriculum,
yes,
there's a fairly strong bill that is in education.
Yes.
And do you remember the House bill number on this?
I don't remember the House bill, but let me just tell you, I will be supporting it.
You will be?
Yeah. Absolutely.
Yeah,
absolutely.
and I would think so. My point is, doesn't this bill overlap a lot with that?
I believe it just pertains to the curriculum. I'll have to go back and read it. So if there's one sentence in there, I guess it has the possibility, but since it's not in law right now, I'm going to say this offers a lot of good access for parents right now.
Thank you. Thank you.
Is there anything else?
And it's HB 1434. Take a look at that.
Okay. Thank you very much, Senator. Are there any further questions for Ms. Banfield? Seeing none, thank you. The chair will call, it looks like Michael Donnelly.
Good afternoon, Senator, members of the committee. It's good to be back in the Granite State. My name is Michael Donnelly. I am Senior Counsel and Director of Global Outreach for the Homeschool Legal Defense Association. I'm also here speaking on behalf of ParentalRights.org, which is a national advocacy organization for parental rights. The tagline of ParentalRights.org is protecting children by empowering parents. I'm a graduate of Boston University School of Law. I have an LLM from the London School of Economics in Human Rights Law. I'm admitted to the bars of New Hampshire, Massachusetts, West Virginia, and the District of Columbia. I hold 2 adjunct professorships, one at Patrick Henry College, where I teach constitutional law, another at Regent Law School, where I teach international human rights law. I've published a lot of articles on the issue of home education, as well as parental rights in peer-reviewed journals. I'm also a New Hampshire taxpayer. We come up every year to our 230-year-old farmhouse in Enfield built by John Story, who was a Revolutionary War soldier, which we treasure that property and we take care of it. I'm also the parent of 7 children, ages 11 to 24. We have hundreds or thousands of individuals here in New Hampshire who are a member of our organization and who are connected with us with 107,000 families all over the country. We support HB 1431, and we would ask that you would recommend that it pass. It's a common sense bill. It's premised on 100 years or more of Supreme Court jurisprudence, and you can read the testimony. I'm going to cut to the chase and just address a couple of points that have been made. There's a long body of federal jurisprudence which recognizes that parents' rights are indeed fundamental. There's no question about that. In Troxel v. Granville, the court said that the liberty interest of parents to the care, custody, and control of their children is perhaps the oldest of the fundamental liberty interests recognized by this court. They're a little bit vague at the federal level, and one wonders whether courts are really the place for, federal courts especially, to be determining what is and what is not a parental right, which is why I think this bill is particularly helpful, because this is where you as legislators can determine specifically in statute what the state is going to respect and how it is going to do that, which is the role of the legislature versus the courts. As I was listening to some of the folks who are opposed to this bill, I was wondering if I was reading the right bill, because some of the concerns that they were raising, I was struggling with trying to figure out how that would actually happen. For example, how it would not allow child abuse investigations, as the Office for the Child Advocate suggested, which I think is absurd to even suggest such a thing, because this bill does not in any way override existing law. It provides specific protections and expectations in certain areas, but and there may be, I suppose there could be conflict, which you would have to address through court decisions and interpretation, but I find this bill to be particularly carefully written. And I do not think that it would do what the Office of the Child Advocate said, which is not allow CPS investigations, which is what I thought I heard her say. I find it a little concerning that the Office of the Child Advocate is trying to pit parents against children, when in fact parents are the best people to protect children's interests. Now, does the state have a role to intervene when children are at risk of harm? Of course. And this bill does not interfere with the state's obligation or ability to do that, in my opinion. When it comes to the best interests of the child standard, I want to just point out that the only time the state invokes that standard is when there is reason to believe the parent is not acting in the best interest of the child or is harming the child, which is what the law that the child advocate's representative pointed to. But that's only in court. This doesn't deal with those issues. This is regarding what to do in public school. There's the amendment which talks about medical decisions, and I can tell you that having practiced in this area for 15 years, all around the world, there is absolutely an effort by some to push parents out of the lives of children. It's not just here in New Hampshire. It's not just here in the United States. It is everywhere, because there are those who think the state should be making those decisions. And so you have an opportunity here before you with this bill to make a decision about whether you believe parents, good parents who are not, accused of abuse or neglect, are the ones who should be empowered to protect children. By the way, I just also want to point out some of the other, one of the other opponents, I think from the social worker organization talked about, and I think Senator Kahn brought this up, about the conflict regarding lines 6 through 10 on page 2 about whether that would interfere with reporting of abuse and neglect. This talks about suspecting a criminal offense. Abuse and neglect is not a criminal offense. Now, some would say it ought to be, and I would argue there ought to be those kinds of due process protections for parents, but Senator, this applies to criminal offenses. Abuse and neglect is not a criminal offense, and therefore this section would not prohibit teachers or other mandatory reporters from reporting abuse or neglect. So I think it was a good question, but I just want to give you my opinion on that. In the area of medical, I just want to make this observation when it comes to parents. Parents are in desperate need of help from you, state legislators, to have some tools that they can point to protect their children. Parents are becoming afraid to take their kids into the emergency room for fear of inviting social worker investigations. Is that the kind of society we want to have? I hope not. But they go in there and, their checklists and, everybody assumes that the injury is potentially abuse of neglect. Now, you can look at doctors need to make decisions and they think there's a reason to suspect something, they should report it, of course. But is that the assumption that we want? No. And in many cases, parents are experience interference in making good decisions from when the medical community is wanting to make a different decision. Okay, I talked to a family just recently in another state, and this happens in New Hampshire too. They didn't want to stay overnight in the hospital. They had a healthy newborn, nothing wrong with the child. They wanted to leave. They wanted to go home. They had 4 of their kids at home. Mom's like, I want to sleep in my own bed. And they said, no, you can't leave. It's our policy to report you to social services if you want to leave within 24 hours. This was not in New Hampshire, but that kind of thing happens. It's just an example. And so that's the kind of help that parents in this country, in this state need from you. They need these tools, and the state workers need them as well. They need to know what is expected of them. So I would urge you to pass this bill. It's a good bill. It's carefully written. It does not put children at risk. It does not interfere with the state to carry out its obligations to protect children, but it does empower parents to better protect their children. Thank you.
Thank you very much for your testimony. Are there any questions from the committee? Okay, seeing none.
Thank you,
very
Senator.
much. Chair will call Representative Nelson. Representative Nelson, we've had quite a bit of testimony on this bill already. Is there something new that you would like to add to the discussion?
Thank you, Madam Chair. I just have a couple of comments as I am a member of the Family and Child and Family Law Committee. I wasn't planning on testifying here. I just wanted to let you know that I am not in support of Senator Guida's amendment. The reasons being is the language portions of the bill regarding health care and also the punishments. I am in support of the bill as amended that came from the House. Reason being is that although my personal experience with the public school system in terms of being open, being able to ask questions about and see curriculum has been very positive. We heard many people testify that that's not the case. They are not, they're not given proper access in a timely manner, sometimes not at all. And also sometimes parents are not given proper access to inside the child's school so they can observe certain things that concern them about the school. And that's it. Thank you.
Thank you, Representative. Are there any questions for Representative Nelson? Thank you very much, Representative. The chair will call Emma Savigny. Ms. Savigny, we've received a lot of testimony on this issue and we're interested in hearing something new. So please don't repeat testimony we've already had.
Thank you, Madam Chair. I will be brief and try and hit only new topics. My name is Emma Savini. I am the Children's Behavioral Health Policy Coordinator at New Futures, which is a nonpartisan, nonprofit organization that advocates, educates, and collaborates to improve the health and wellness of all Granite Staters. I will just hit on two kind of concerns we have with the bill. The overarching concern we have and why we oppose it is that it creates a tension between schools and parents, which leaves the child to suffer essentially. So one example of this is the multi-tiered system of support, or the MTSSB, which is a evidence-based practice, and it helps support strong social, emotional, and behavioral supports within schools so that students are able to learn, not just in the academic traditional sense, but also socially and behaviorally, how to act as good members of society. When parents kind of get the distrust in school systems that is bred by this bill, school programs such as MTSSB would suffer, and the culture and climate of schools would in turn suffer, and students would again suffer. Secondly, this bill creates a lot of distrust within the schools over various topics, one including allowing parents to opt out of surveys that are provided in schools. Parents already have this right enumerated in RSA 186. This has come up in another bill that's in the Senate right now with the Youth Risk Behavior Survey. And so this survey is a really important data collection tool to help student services, administrations, nonprofits, the state collect health and wellness data on students so that we can track and ensure that students are acting in a healthy manner, or if they are not, come up with appropriate programming to assist them in making healthier decisions. This is already an opt-out survey, so parents have the right to opt out at any time. But by putting it in this bill, it creates a sense of distrust amongst the community and the school district towards the school, that the school does not have the best interests of the child at heart. And so when these senses of distrust are formed by the rights in this bill, which are already enumerated elsewhere, the students suffer and the children suffer. So for those reasons, New Futures asks that you vote this bill inexpedient to legislate.
Thank you very much for your testimony. Are there any questions from the committee? Okay, seeing none. Oh, Senator French.
Thank you. I'll keep it brief also. So it's your testimony that this bill creates distrust among the people, or it's created because of a distrust between the parents and the schools?
Thank you for your question, Senator. I think it's a little bit of both, but I think by having these rights in a Bill of Rights where the rights are already enumerated elsewhere, it creates a sense of tension between the schools and the parents, which is fueled by distrust, whether it comes from this bill or it comes from elsewhere.
Thank you.
Any further questions? Seeing none, thank you very much. The chair will call Jama Wilder.
Good afternoon, and thank you for your time. My name is Jama Wilder, and I live in Hollis, New Hampshire. And thank you for your desire to protect our children and our children's rights. I was born and raised in New Hampshire and spent most of my 41 years living in our beautiful state. My husband and I have 5 children, ranging from 13 to 17 years old. We enrolled our older children in the Hollis Brookline High School. Starting in August, I requested a complete list of curriculum, including textbooks, movies, and reading assignments. I was denied on multiple occasions and told I could log into my children's Google Classroom to see what resources the teachers were using. On several occasions, my children came home with questionable material riddled with inappropriate sexual content, divisive concepts, and reading books with a lexicon level of a 4th or 5th grader. In some classes, they were only allowed to go to one resource assigned by a teacher to do their resource. The resources were very biased. This practice is stunting the growth of our children to be critical thinkers. When my daughter attempted to add a direct quote to an assignment to give her interpretation of the quote, she was told her project seemed argumentative and she needed to redo the assignment. Through the last several months, I would look on their Google Classrooms and could not find the resources my children told me about. There was absolutely no transparency. I wanted to be able to have a clear picture of what was going on in the schools, so I completed the 6 hours of volunteer training. When I completed all of the requirements, training, background check, and fingerprinting, to my surprise, I was denied the opportunity to volunteer through the school. The principal told me the school doesn't offer them, even though they were short pairs and teachers at the time. I would need to find opportunities through the Parent-Student Teacher Association. I then requested to observe a class citing ESSA 1116C, parental engagement. I was denied by the superintendent and the principal. They said I was denied based on the collective bargaining agreements and student privacy. In our district, I could put in an application to substitute teach without a teaching degree and be running my own class. After questioning the things I was seeing, the administration informed me that I was not allowed to meet with a teacher or question them about curriculum, and all questions should go through the administration. It became very clear to me that they didn't want me anywhere near the school. The hyper-focus on sexuality, divisive concepts, and the constant focus on their social and emotional learning is planting seeds in these developing minds. It's destructive for our children, and as a parent, I should have the opportunity to voice my concerns and be heard. After working tirelessly for 6 months, I came to the conclusion I had no other option than to remove my children from the public school education until things changed. I have seen a complete shift in our education system in the last couple of decades, and as a parent, this is frightening. This bill is so crucial to me because it defines the parental rights in our children's education. It appears to me that some administration have forgotten that the children belong to the parents and not the public school. The job of parents is to direct the upbringing of our children in the moral and religious training, education, healthcare, mental health, and unconditionally love them. I would ask that in section 169I3, you strike the line in the section that states, without demonstrating that such action is reasonable and necessary to achieve a compelling state interest that has such action is narrowly tailored and is not otherwise served by a less restrictive means. Every parent has been blessed by God with our precious babies, and we know what's best for them. They belong to the parents, not the state or the government. Please ought to pass and give the rights back to the parents so we can protect them and raise them in the way they should go. I did want to add one note about what the person before me said. The survey, the youth risk survey that she mentioned is an opt-in or opt-out, but our school never gave us the option. So I got a phone call from my children. Our district broke the law, and a week later we had a suicide in our school district. And there are so many things that are going on that they're not doing what they're supposed to be doing, that by you giving us these rights, we have an RSA to go to and say, we have a right and we should be involved. And I thank you so much for your time and your consideration.
Thank you very much for your testimony, Ms. Wilder. Are there any questions from the committee? Senator Gannon.
Just a quick question. Would you if we pass this Bill of Rights, would this be a step forward to your bringing kids back to a public school?
Yes, I feel that if there was an option for parents to have a right, that they were able to be involved. Right now, it just feels like there's so much divide, and if you don't agree with something that they're doing, they have a way of stopping you from having any involvement.
Thank you.
Thank you.
Thank you very much. Okay, everyone who has signed up to speak has spoken. We're going to go ahead and close the public hearing. What?
Oh, they get
I know,
tougher.
we should be able to go through. It shouldn't be.
There's only 5 more.
Pardon?
There's only 5 more.
Oh, hey, you better get used to us. This is how we're gonna be moving. This is how we're gonna roll. We have no
That's right.
choice. We got no
See, if
choices.
you can't keep up with the chair,
Yeah.
get off your chair.
Oh, goodness gracious. Well, I think what I'm going to do.
Yeah, it was good. He was, yeah. Of all the ones,
Yep.
that's the one. Yeah. Sharon, Bill and I have to go out.
I don't care.
Would you join us? I'm kidding.
Are you upset? Okay. We're going to go ahead and open the public hearing on House Bill 1592 and call the prime sponsor, Representative Gay. Good afternoon, Representative.
Good afternoon. Oops. This should be a short bill. It's to allow parties in family court to create their own recordings of the proceedings. It's very simple in that it does not nullify any court processes. This bill is important because we use the recordings of hearings for any further legal action. But several parents have told me that when they purchased official court recordings, and the very expensive transcripts of these recordings, many critical statements made in court were missing from the recording. Now, if only one person had told me this, I wouldn't be convinced. But countless people have told me their personal experiences receiving a recording with missing dead spots, as if the recorder was turned off and on at critical points that they were hoping to have a recording of. The easiest way we can fix this problem is to allow the parties to make their own audio recordings. Nowadays, that can be done easily and unobtrusively with cell phones without fanfare. Care is taken in this bill to limit the audio-only recordings to just the parties hearing, with warnings to all the people present in the court. So nobody's going to surprise somebody with a recording. Parties do not have lobbyists. Naturally, the court staff personnel may feel like their authority is impinged, but in no way does this bill remove any of their rights or actions. I suspect the court likely will be opposed, but they threaten, this is no threat to their authority or their ability to do their work. One person is here to testify who has experienced this. 2 more people were prepared to testify to their experiences, but their own work schedule at the orthodontist or at the State House office mean they will be submitting written testimony later today. So today you'll hear from Adriana Buttafoco, who has spent several $1,000s on official recordings and transcripts.
Okay, thank you very much for your testimony, Representative. Are there any questions from the committee? Okay, seeing none, thank you.
Thank you.
The chair will call Representative Stapleton.
Thank you, Madam Chair, committee members of the committee. For the record, I am Walter Stapleton, New Hampshire House Rep, Claremont, Ward 3, Sullivan County, District 5. I am a supporter and a sponsor of HB 1592. And you know, this should be a simple bill. It's not much different than from why we take notes, to have recall of what we hear for reflection, proofs, corroboration, or even for settling differences or missing pieces. But unless you're a professional stenographer or a court reporter, note-taking can fall fast behind a proceeding, especially when you're under stress. So the audio recording is a better tool for many who are not practiced note-takers. Allowing the people to make those records for their further review and reflection really makes sense. Because they might want to reflect on those, or maybe there is a difference in what has been transpired in the proceeding, especially if there's a failure or shortfall in the official recording with the equipment and so forth. So basically, this should be a simple bill for the rights of people in a proceeding to assure that they have adequate and a backup and a recording of their own to compare against the official record if there's a dispute or difference. So I'd ask you to please vote ought to pass on HB 1592.
Thank you very much, Representative. Are there any questions for Representative Stapleton? Seeing none, thank you very much,
Thank you.
Representative. Okay, let's see. The chair will call Keith Kuning. Oh, he's not here. Yes. Keith Kuning? No? Okay. The chair will call Richard Head.
afternoon, Madam Chair, members of the committee. My name is Richard Head. I'm the Government Affairs Coordinator for the Judicial Branch. I wanted to point out a couple things. One, that the bill is unnecessary. All the divisions have current rules that govern recording photography. And so, for example, family division, which is what this rule or this statute would purport to affect, has a rule 1.29, except as otherwise provided by this rule or other provisions of law. Any person, whether or not a member of an established media organization, shall be permitted to photograph, record, and broadcast all court proceedings that are open to the public. So there are a couple very key parts to this. One is it requires permission of the court. It has to be a proceeding that is open to the public, and the parties have the opportunity to object. And that's important because if we think about what family division is, and this bill would cover all of family division, talking divorce, parenting, child services, domestic violence petitions, guardianship of minors, termination of parental rights, abuse and neglect cases, children in need of services, juvenile delinquency, and adoptions. This bill, as written, would not allow the judge to in any way restrict those recordings, so confidential matters would be recorded. Abuse and neglect cases could be recorded. Domestic violence could be recorded. And the court does not have control over those recordings. They could be broadcast in social media, manipulated. Anything could happen to those recordings. So what we do have is a rule that says you cannot record confidential proceedings. You cannot record certain things. And if it's going to adversely impact the proceeding, then the judge has discretion, or the parties can raise, no, this is going to cause testimony to be affected, it's going to impact something, or, here are the ramifications. The court can then receive that information. As this bill is presented, there is none of that discretion. There is no type of proceeding excluded within the family division from this bill. So I would say it's unnecessary because we do have a procedure to allow parties to seek to record. And two, it is potentially extremely damaging. And three, creates significant problems relative to confidentiality, domestic abuse, domestic violence, and just a range of cases that the court would not be able to consider if this bill were to pass. And I'd be happy to answer any questions. Thank you.
Thank you very much, Mr. Head. Are there any questions? Senator French.
Thank you, Madam Chair. Thank you, Mr. Head. Are the rules of the court set by the courts or by the legislature?
The rules are set by the courts. There's a rules committee. Two legislators sit on the rules committee, but they are set by the court.
Well, so I thought. And just like the Senate votes on their own rules and the House votes on their own rules, the courts set their own rules.
Preferred way to do it, but we do obviously one input, but not through legislation, through the rules committee.
That's what I thought. Thank you.
Thank you for the question.
Senator Khan.
Thank you, Madam Chair. Mr. Head, thanks. I noted that in the House hearing, or House vote in committee, it was overwhelmingly in favor. Did you present this testimony to the House committee?
I did.
Did they listen to you?
Okay.
I won't say thank you for the question.
Mr. Head, I'm glad that you raised the concern because we live in an age where everything is social media. I mean, look here now, everything we do is broadcast. And I'm concerned that family courts, as you know, are very, very messy. And one side's taping the other side. The next thing you know, it's going to be out there on YouTube or someone's posted something on Facebook. I just don't know what the effect of that would be. It just seems that I can understand why someone would want to audio tape, but I can just see a lot of issues arising from that. So if you can send us the citation from the court rules or provide us with a copy of the court rule for our record, I think that would be very helpful.
I would be happy to. And to that point, I think it's it is exactly that type of concern where that recording can cause significant damage to an individual. And it's a great concern. We also, On the flip side, I understand the issue of the recordings do not always come out perfectly. We do, just as information, we did issue an RFP for an updated recording system. We've selected a vendor. We're implementing that. So we understand sort of the technical issues we've had occasionally with recordings, and we're working to replace the system with an updated system that hopefully those problems will not occur. But, you know, I sort of get the concept of a backup recording system. There is at least a current rule that does allow, if the type of case provides for it, for the parties to record, and I'd be happy to send the rule.
I do have a few other questions. So if you have two parties in court, and you've got, I imagine you've got the court stenographer who's doing that, or is it recorded?
It's pure, so currently in circuit court, there used to be a court, well, historically there was the court reporter. We took that away, went into a court monitor who would monitor the recording. We removed court monitors as part of a budget cut, so now as was testified to, it is the judge in the courtroom turning the machine on. You usually have to step down from the bench because it's down where the monitor used to be, and then there's a clock that shows that it's running. But it's a fairly mechanical process of doing it. But it's now a recording turned on by the judge, usually just runs through the day, and then is the record of the case.
Is there a way for the parties to get access to that verbatim tape?
Absolutely. It's a request to the clerk, and again, assuming, depending on the type of case, if it's confidential, there's some issues. If it's, they're always available for appeal, because that is the verbal record on appeal. And the recordings can be requested, and you get a copy of the recording.
I'm not talking about a transcription of the recording. I'm talking about the actual recording.
The actual recording can also be requested.
Okay.
So just the audio recording.
It can be made available.
Yep. There's a form, and I can't remember what the fee is. There's a fee associated with it.
Okay.
$25.
25? Everything is 25. Thank you very much, Mr. Head. Are there any further questions from the committee? Seeing none, thank you.
Thank you.
Okay, the chair will call Maria Iscott. Good afternoon.
Good afternoon. A little nervous. My name is Maria Iscott, and I have been in the family court system, or was, for a period of 7 years. To put it gently, there are a lot of shenanigans going on in the family court system. Just to bring up some things that you just spoke about, the recording's a button on the judge's desk. It's not, it's turned on and off at the judge's will. So I'm just responding just from experience. 2 years into the court system, with the divorce decree, there was a fault ground divorce due to domestic violence and abuse. Yeah, I kept in the court system with my children for another 5 years. And it's a mixed bag, but there are some judges that are questionable. And for some examples, towards the end, everybody comes with a bias and a worldview, regardless of previous orders and findings by the court. The judge, for a few examples, some things that the judge stated during a hearing, and unbeknownst to me, off the record, he had said, and I wrote this down thinking that when I went and got the transcriptions, which we can only get through e-Scribners, which cost hundreds of thousands of dollars for each hearing. These are some following comments that we had written down that were not in the transcripts. There's pauses in them. Like I said, the judge can decide when to turn that off and off. He's not walking around. It's either a pedal on their foot pedal or a hand pedal. These are quotes. In my courtroom, it is about father's rights to have access to his daughters. Keep in mind that there was already a finding of domestic violence. My court, my rules. At the end of 7 years, I had no more money. The attorney fees were over $50,000, and I lost a lot of money to protect my kids. But it was stated, if you don't agree to joint custody, then I'm going to make an order, and I promise you, you aren't going to like it. So I ended up with joint custody after I had sole custody for 7 years with this judge. Another comment that he did in court was he refused to allow a court-ordered therapist into his courtroom to testify in favor. He had come to previous courts. This is was court-ordered in the second year, and he stayed with the court. He had come many times. Each time he came, he testified. The children's best interest is with the parents. So, and there was another question about, and it's a valid question that you had placed, is, do I want these recordings out in, on YouTube? And absolutely not, because these are my family, my children. I wasn't even going to discuss this, but just of some things that have come up, just to really inform you guys as to what is going on in the family court system. Like I said, some of it's been okay, and then there's just some shenanigans that are, I don't know if it's an amendment in there, but it should be limited to allowing the recordings to the parties, to their attorneys or the parties, and it should, I don't know if that could be in there, but it should not be allowed in any shape, way, or form to be put into the public. It should only be used if there's a discrepancy between the transcript and the parties' recordings, because I can tell you right now, I am one person, but over the last 10 years, I have had dozens of women approach me. How do I manage the court system? How do I work? This has happened to me. I'm just not one person. There's dozens of other people that have come before me and that have come after me that have had these problems. But if the recordings could be limited to the use of only in court for this discrepancies, because I do agree with you, they should not be allowed or to be limited to just the court and not social media, because that would be good, but it is needed. Kefi Annan once said, if corruption is a disease, transparency is an essential part of its treatment. And I feel like this is just one piece of the puzzle. I'm sure it's not a surprise to you that there's issues with the family court system. So I just would please ask you to vote ought to pass for Bill 1592. Thank you.
Thank you very much for your testimony. Are there any questions? Senator French?
Thank you, Madam Chair. Thank you for your testimony. Can you tell me how you would use the recordings of the judge's statements to benefit your case?
Okay, these statements that I read were not in the recordings.
I understand.
Okay.
So if you had the right to make your own recordings, how would you use those to benefit your case?
There have been illegal things that have happened during my hearings and other hearings. And if everything's recorded, it's all out, it's all transparent. I've always, because my attorney at the time always insisted that I get all the transcripts, and the transcripts are useful because in the family court system, they seem to drag things on ad nauseum. And when you get bounced from judge to judge to judge, you need those transcripts. So to have the transcripts from the point that the hearing begins to the point it ends, it's everything in the open. Do you understand? Like, it is wrong that a judge was telling me, you have to do this, or in knowing other people that came before me in similar situations, I wanted to do what was in the best interest of my children, and that was them me continuing having custody. So it's necessary for transparency reasons to keep everything on the up and up is to have these recordings. If there was a way that, if there was a law that the gentleman before me, he said that the recordings are turned on at the beginning and turned off at the end of the day. That is not the case. There are many pauses in between. I mean, if that was the case, then we wouldn't need this, but it's not the case.
Thank you.
Thank you.
Are there any further questions? Seeing none, thank you very much.
Okay, thank you.
Are there any other members of the public that would like to speak to House Bill 1592? Okay, seeing none. Representative Gay? You really need to do that? Less than 1 minute, please. Come forward.
Thank you. I really agree with you that there needs to be an amendment that says the use of this recording. It should be restricted to use in court only, and I'm very grateful to the Judiciary Committee for rounding out and amending the bill as it is, and I really thought that they were discussing putting in that restriction on the use. So I would appreciate if y'all could amend it.
Thank you very much, Representative.
Thank
We're going to
you.
go ahead and close the public hearing on House Bill 1592. Okay.
I see what happens when I say breasting.
Yeah.
It's just everything.
Okay. Yes, sir. Going to go ahead and open the public hearing on House Bill 1612 and recognize the prime sponsor, Representative Spillane. Good afternoon, Representative.
Good afternoon, and thank you, Madam Chair and esteemed members of the Senate Judiciary Committee. I bring before you today House Bill 1612. As amended, this bill was passed by the House of Representatives and is supported by the Director of DCYF. I initially submitted a version of HB 1612 to address a growing but long-standing problem of weaponization of the DCYF agency through false complaints. These false complaints take valuable and limited time away from the agency and legitimate cases, and the making of a false complaint has no penalty under New Hampshire law. False complaints are made for any number of reasons, from custodial fights in family court to political attacks to simply a disgruntled neighbor. DCYF is a critical agency that deserves our full attention and should not be drawn into situations under false premise without penalty. It is illegal to file a false police report or to call in a false fire emergency, but when people abuse the DCYF reporting system, they face no penalty and thus may not take their actions seriously. Repeat false complaints are not entirely uncommon once someone realizes that there's nothing to deter their actions. When I proposed my original version of HB 1612, the director of DCYF was in the committee, and he had expressed that it had merit, but that he had some issues with the implementation. I worked with the director to identify and satisfy all of his concerns, drafted an amendment, and the vice chair of Children and Family Law introduced it to the committee. What you have before you is that amended language, which provides a penalty for false reporting to DCYF. It encourages the taking of a confidential report with contact information, but without prohibiting anonymous reports when a person may have reticence to identify themselves, and allows the employee at DCYF who takes the report to remind the complainant that a false report can incur a criminal penalty, but it does not mandate that such a warning be given. The flexibility in these two actions was requested by the director of DCYF, and I think that they are well-founded in the fact that we don't want to discourage a genuine complaint just because we demand information about the person's identity. So they have the flexibility to say, we'll take your information, but if they insist that they don't want to, they can still take the report anyway. We changed the shall to a may. Same with the warning. The shall was changed to a may so that the director could have some discretion with his caseworkers that if they took a report and the person was obviously a first-time reporter, they did not need to try to make them feel skittish about the situation by giving them a warning about there being a criminal penalty if it was false. But if they recognize the person as someone who called frequently, they have the language now to give them such a warning. The bar for the criminal penalty is pretty high. As you can see in there, it has to be intentional and with malice that the person makes the false complaint. As such, I don't believe that you'll find any first-time complainant can be proven to have made a false accusation unless there's extenuating circumstances. This is more to establish a pattern of abuse and then put the penalty in place for those who abuse the system. I ask you to support HB 1612 and support the effort to reduce time-consuming and harmful false complaints to DCYF. And I would suggest that a better title for this, because the title that's there is cumbersome and does not accurately reflect what we're doing, would be enacting a penalty for false reporting.
Okay, thank you very much for your testimony. Are there any questions from the committee? Seeing none, thank you very much, Representative.
Thank you, members.
Okay, the chair will call Representative Alicia Lakis.
Thank you. For the record, Alicia Lakis, representative of Hillsborough 37 Hudson and Pelham. I came to give you an example of false reporting. I lost my granddaughter when she was a baby for over a year because of a jealous girlfriend. A girl who thought that her boyfriend was going to visit my daughter-in-law when in fact he was going to visit my son, who he'd gone to school with. And she knew when my granddaughter was being babysat so that her mom could go get driver's instructions because she grew up in Seattle where she didn't need a driver's license and came here with my son to New Hampshire and found that she did. So trying to make the situation better, she was going to do that. And while my granddaughter was at the babysitter's, the girl called and reported her being abandoned and neglected. And they came and took her, and it was over a year before we got her back. She had to jump through all kinds of hoops. And in fact, before getting her back, they told her that she had to get a toddler bed because she'd outgrown the crib and they didn't think she'd grown into a single bed yet. Well, how many parents have toddler beds? But she had to do all kinds of stuff. This was a critical time for my granddaughter when you are bonding with your parents, et cetera. She was a baby, gone for all of that time. And caused stress, as you can imagine, between my daughter-in-law and my son, and they broke up over this. And then when we actually got to go to court over a year later, no harm was found whatsoever. My granddaughter was returned. And then they charged her for all of the expenses of that year that they had her. And my daughter-in-law left the state because she couldn't pay that. And this was just a jealous girl. Called it in and caused all this harm. So this is why I really support this bill. Thank you.
Thank you very much for your testimony, Representative. Are there any questions from the committee? Seeing none, thank you very much.
Thank you.
The chair will call Representative Yokela.
Thank you. For the record, Representative Yokela, Rockingham 33,
Fremont, Danville, and Brentwood. I wrote the majority report on this bill in the House and from Children and Family Law. And so I just wanted to share some of the information that we had over on the House side. I think that the changes as amended address a lot of the concerns. There was a lot of concerns about whether or not people would be afraid from not being able to make anonymous reports. And so having the anonymous report language added back in made the committee, or majority of the committee, very satisfied with the language. There was some concern about the release of people's names, and they wanted to make sure that they were confidential. Those names were kept confidential if there was no, examples that he gave of malice. And I would just point the committee to page 2, line 13 and 14, where it says, under no circumstances, the identity of the complainant who makes a report of suspected abuse or neglect in good faith or pursuant to this RSA 169C:29 be released. And so that's a pretty strong protection that the names are going to be kept confidential unless it's been proven that it's not been in good faith. And so I think that this bill is good, and I hope that the committee will support it. Thank you.
Thank you very much, Representative. Are there any questions from the committee? Okay, seeing none, thank you. The chair, okay, I don't see Mr. Kuning. Is Mr. Kuning back? Okay, so he's not here. The chair will call J.R. Hall.
Good afternoon, members of Senate Judiciary. J.R. Hall, former state rep, Dunbarton, testifying in favor of House Bill 1612. This bill seeks to correct a longstanding problem of anonymous complaints. Unlike anything else in the criminal justice system, right, where the firsthand person who takes notes and is aware of what happened, and who can be cross-examined or deposed later on in a criminal proceeding, our current laws allow for an anonymous complaint to kick off a series of government events that then potentially create real harm. The benefit to actually going to confidential is several-fold. First, it will automatically, at some level, start to filter out false reporting. The moment someone realizes that they have to put their name attached to this complaint, they're going to be much more concerned about the information they're sharing. Things like hearsay won't be, oh, I heard so-and-so saw, type complaints will go away. Secondly, the current bill as modified by the House uses may in section 1 for reporting instead of shall. I would encourage you guys to go backward to shall. I think it's important. The may on the disciplinary side makes sense to me, but the capturing the information, and that goes to the constitutional side of this. Part 1st, Article 15 is extremely clear about the ability for anybody who is being held to answer for a crime, or in this case, an offense, and a lot of these that are going through DCYF are offense level things, not necessarily crimes, to be able to meet with the witness, right? And to be able to cross-examine them or to be able to meet with them face to face. So what we have today in our statutes is actually an unconstitutional allowance for someone to make a complaint and then that to be used against them. And as mentioned by one of the other witnesses speaking in regards to the bill, this allows this state agency to be weaponized between one person and another. I would ask that you would pass this bill, making the one change that I suggested. Thank you.
Thank you very much, Mr. Hall. Are there any questions? Seeing none, thank you. The chair will call Michael Donnelly.
Good afternoon again, Senators. Michael Donnelly, Senior Counsel for HSLDA, Homeschool Legal Defense Association, and also speaking for parentalrights.org. Why would homeschoolers be concerned about false reports or reporting of abuse and neglect? We have decades of experience. Prior to homeschooling being recognized in the early 90s, it was not recognized by law, and people did it, and they got reported to CPS, and they went through investigations. So we have helped the homeschool community, and we continue to help the homeschool community because people still report homeschool families for truancy, for not being in school, et cetera, and other things, because nobody's perfect, no community is perfect, right? So we help them, and so we have experience with this. National statistics, 96% of anonymous reports unfounded. 83% of all reports of abuse and neglect unfounded. What does that tell you? That's all you really need to know to be able to pass this bill. But what that means is we have a incredible false positive issue in the CPS system. Every single social worker agency, the CPS agency here in New Hampshire, every CPS agency should be in favor of reducing the number of complaints of abuse and neglect that are inaccurate, malicious, not really allegations of abuse or neglect. Why? Well, the man was here earlier showing 25 dead children. When social workers have to go out and check on a homeschool family or check on kids who are running around outside without their shoes on, and it's New Hampshire, it's March, so it's warm, right? Okay, which happens. Okay, that happens. I'm not making that up. Or check that the family doesn't have curtains in their second floor windows. Okay, I could go on and on and on with silly stuff. Every time a social worker has to go and knock on the door of a family's home, which is traumatic, by the way, don't tell me it isn't. Don't listen to anybody who tells you that it's not. Anytime a government agent shows up on your door and does this with the power to take away your children, it is traumatic above and beyond anything that any parent could experience. So everyone should be concerned with reducing the number of complaints in this system. We need to do more. More should be done, but this is a good first step. So I would encourage you to support this bill, and you can read the rest of my testimony, which has more evidence, research, and national statistics. Thank you very much. Happy to answer any questions.
Thank you very much for your testimony. Are there any questions from the committee? Seeing none.
Thank you, Senators.
Are there any other members of the public that would like to speak to House Bill 1612? Okay, seeing none.
Madam Chair, just want, is there anybody from DCYF present?
No, no one has signed up to speak. Sorry. That's why I asked. We've already closed the public hearing. So if you would like to give us... I've already closed the public hearing. Senator, if you would like to reach out to Ms. Ross to get information, I would encourage you to do that. If we went to open it up again, we'd have to have 24-hour notice, all of those other things. So, pardon? Yeah, that's the problem. The gavel came down and I asked. Okay. Thank you, John. No one's speaking on this. And who is the prime sponsor? Representative Edwards. Okay. Hey, we move fast. Gotta pay attention. Okay, there were no amendments on this bill. Okay, you all set, Jenny? Okay. Gonna go ahead and open the public hearing on House Bill 1614. Is Representative Edwards here to introduce his bill? Okay, I don't see Representative Edwards. Representative Ukella, I'm going to ask you to introduce the bill because you're a House member.
Thanks.
Do you have a copy of the bill?
Yes, I do. I was planning on speaking on it. I signed up to speak on it.
You might have
Maybe.
signed up to, you signed in, but you did not sign in.
Oh, sorry.
So I will check
mark
that
to-
off for you.
Thank you. Thank you, Senator Carson and members of the committee. Again, my towns are Fremont, Danville, and Brentwood. And I was on this committee when we heard the testimony for this. And so what is being requested in HB 1614 is that they record the public areas of detention facilities inside of the state. There's only detention. We only detain people inside the state. So the only detentions they wanted to record the public areas of that. And they wanted it to be kept for essentially the entire statute of limitations. Currently, it's only being kept for about 2 to 3 years, I believe was the testimony from the House. And sometimes complaints happen after that time, and they would like to either be able to use those recordings in court to defend themselves or to exonerate or ensure that justice is done when the person is complaining that something has happened to them. And there wasn't very much, there wasn't any opposition that I heard in the House. Since they're already doing this, there was just confusion sometimes about what is a detention facility, where are they, what are we talking about? And I believe that so there's a difference between actually detaining someone, which is before they are going to court and having the decision, and after that, that is a judgment is rendered on them and they're committed. That's a different kind of thing. So it's just during the detention before they go to court and receive a judgment. And so that is the kinds of facilities that we're talking about, and only ones that are funded in whole or in part by the state of New Hampshire. So if they're there was an example of a kid in foster home out of state, and they get arrested and they're detained in Massachusetts or something like that. We, as a state, didn't fund that detention facility, so it wouldn't be covered under this. It would be subject to their laws. And so those were the only confusions that we heard over there. And so I think that this language and being up 98% of the time is obviously good. And the requirement that you should be able to see the people and identify them so that you can see who did what when you're defending yourself or punishing someone that did something, holding them accountable. We supported this, and I'm happy to answer any questions.
Thank you very much for your testimony. Are there any questions? Senator Whitley.
Thank you, Madam Chair. Thank you for taking my question. I think the confusion is because we have one facility in New Hampshire, right? And they have both kids who are detained and then kids who are committed.
Right.
So if I understand your testimony, this bill does not apply to those children who are committed to the Sununu Youth Services Center?
Right. Technically, so this bill, I mean, if they were detained in that center, then it would be required that all the public places, but we're planning on getting rid of that. So it's possible that they could be detained somewhere and then committed could be going elsewhere. And so this would only, if we separated that, it would only be in the place that we would only be requiring with this bill that the detention place be recorded in all the public areas. You would need a separate bill that would address the detention area, or not the detention, the committed areas. Thank you.
You said? Okay.
I do have,
Yes, Senator French.
well, after you, of course.
Oh, you go first.
Oh, thank you. So could you just, maybe you don't know, what is the purpose of this? I mean, you're going to be recording activity in common areas, which would be cafeterias and hallways. And you're gonna keep all these recordings because they're gonna be continuously recording 24 hours a day. You're gonna keep this for years and years and years. And that's the intent of this bill.
Yes, thank you for the question. Yes, it is currently the practice. I think so what was explained to us in the committee is right now they are recording those common areas. So you could have like just like a game room or something like that. You would be recording that area also. But there would be, it would be all recorded, and they would be making sure that they could record the entire area. So right now there may be blind spots that they're not recording because they haven't specifically had it set up with the intention of recording the entire area all of the time. And currently they're only keeping it for about 2 to 3 years. So this would extend the time. So it's the technical language in here is retain the data a minimum length of to justice, a minimum length of time as justice may require. So they didn't want to put a specific time frame. They said that the DCYF's people said that they believe that to be the length of the statute of limitations. And so if the statute of limitations was longer or moved, then they didn't want to have to amend this language to, if they said 7 years and it got moved to 10, that they wanted to be able to have that flexibility if the statute of limitations changed. Okay. So, yeah. And yeah.
Are there any further questions? I just want to make sure that I understand this. And basically all you're doing is saying, you're already doing this. You're already videotaping, that instead of getting rid of the recordings after 3 years, you're going to keep them forever.
Not forever, for the length of the statute of limitations, which is currently 7 years. So instead of 3 years, we would be adding it 4 more years onto that. And we may have to, depending on the quality of the current recording, if we're not able to discern who is being recorded or taking those actions, they may have to be upgraded so that we could discern and make sure that there was no blind spots. So those types of things would be required by this new legislation.
Okay, thank you. Are there any further questions?
Maybe one more.
Yes, Senator Whitley.
So thank you, Madam Chair. Thank you for taking another question.
Yeah.
The only thing I'm thinking about is, of course, we all know that there have been horrific, reports over the years, not necessarily all at the existing Student Youth Services Center, and they occur when kids are committed to the facility, right? So are we not, and, there are statutes of limitations if children are, are subject to horrific things there also. And so are we not protecting, why are we not including those children also?
Thank you for the question. So I'm not the prime sponsor of the bill, so I can't be 100%. We didn't go into what this bill is not, kind of a thing, in children and family, and say, like, why didn't you bring us this additional bill? And so I would not be able to answer why they didn't bring the additional bill. Maybe Director Ribson might be able to answer, or the prime sponsor of the bill. I'm not sure. I can only comment on what was submitted. Thank you.
Thank you, Representative. Seeing no more questions.
Okay, thank you.
Okay, are there any other members of the public that would like to speak to House Bill 1614? Okay, seeing none, close the public hearing. Thank you. All these reps. Okay, You ready, Jen? Okay. We're going to open the public hearing on House Bill 1425 and recognize the prime sponsor, Representative Blasek.
Thank you, Madam Chair, members of the committee. For the record, I am Representative Melissa Blasek, and I represent Hillsborough 21, the town of Merrimack. I'm here today to introduce HB 1425. This bill seeks to amend RSA 446. The state of emergency statutes are RSA 445 through 447. RSA 446 grants the executive branch the ability to seize private property during a state of emergency. However, it was not used at all during the COVID-19 state of emergency, and I don't believe it has ever been implemented. However, no one knows what the future holds, and while many of us agree that emergency authority must exist for extraordinary circumstances, that authority should still be tailored to prevent potential abuse of power. People's natural rights do not cease to exist during an emergency, and those rights must remain protected. To quote James Madison, an elective despotism was not the government we fought for, but one in which the powers of government should be so divided and balanced among the several bodies of magistracy as that no one could transcend their legal limits without being effectually checked and restrained by the others. State of emergency powers hand an enormous amount of authority to the executive branch. I believe it is our duty to restrain this authority as much as possible while still allowing for the executive branch to handle any emergency that may arise. This bill makes several changes to the existing statute and adds language that there must be a documented inability to obtain alternative resources before taking private property. It adds more compensation for the taking of the property and ensures that once the state no longer needs the property, that the owner has the right of first refusal to purchase it back at the prevailing market price. This bill justly places the entire cost burden associated with eminent domain during a state of emergency in the hand of the state where it belongs. That concludes my testimony, and I would be happy to answer any questions.
Thank you very much for your testimony, Representative. Are there any questions from the committee?
Yes.
Senator French, you look perplexed.
I am, so maybe you can help me out.
Sure.
So this is to amend the taking of private property compensation.
Correct.
So on line 3, it says this section shall not apply to personal property, real estate, or real estate improvements. What does it
I don't have
pertain to?
I don't have it right in front of me. Thank you.
So when you're talking private property, you're talking personal or real property. So this excludes all real or personal property.
Correct.
So what does it pertain to?
So in past testimony when this bill has been discussed, it was like examples that were used, right? Where let's say there was a pandemic so awful that bodies were literally piling up and you needed to take refrigerator trucks from Shaw's to store the bodies. That was sort of the intended purpose of a bill like this or the law like this, not to take someone's personal home.
Okay. Thank you.
Okay. Are there any further questions from the committee? Seeing none, thank you very much.
Thank you.
Representative. Okay, are there any other members of the public that would like to speak to House Bill 1425? Okay, seeing none, close the public hearing. Oh. Oh, goodness. Okay, there we go.
Oh, yeah.
we have public, okay. I did not. Thank you, Jen.
I was doing it last night. Very good. I liked your shirt last night.
All set? Going to go ahead and open the public hearing on House Bill 1296 and recognize the prime sponsor, Representative Sylvia. Good afternoon, Representative.
Good afternoon, Madam Chair. Very nice to be here. For the record, I am Mike Sylvia, representing Belknap 6 in the town of Belmont. And I'm here to introduce HB 1296, a bill that will further reform asset forfeiture. I've passed out testimony, so I won't pester you with reading the whole thing. 2016, we, supported by the Honorable Dan McGuire, along with Paul Birch and Claire Roulard, a very bipartisan group, made our first step towards reforming civil asset forfeiture and going with a criminal asset forfeiture system. This adds due process protections to our citizens, which are guaranteed by our Constitution. When this was implemented, it left a little bit of room for improvement. It was implemented and instituted a two-track system where the seized asset was held aside for forfeiture later after a criminal process on the criminal charge, so that after the criminal process was finished, then the forfeiture would happen in a separate civil trial. So obviously, asset forfeiture is a good tool, but it can be abused, and we want to make sure that we get the best protections for our citizens. So in New Hampshire, we have essentially three paths related to asset forfeiture. We have an in-state process where law enforcement makes a seizure in connection to a felony level drug crime. The process is run through the court system under our criminal asset forfeiture proceedings. That's the current state of affairs. And of course, as I mentioned, this was involves two cases, lacks the efficiency that we're looking for with HB 1296. The second and third methods of asset forfeiture involve a federal program called equitable sharing. Equitable sharing has two branches to it. The bulk of that, 70%, is through joint task force operations. These are operations that are held in conjunction in agreement with federal officials, and those processes, all of those assets, are going through the equitable sharing program. This bill does not affect them at all. There's a second part of equitable sharing, which is called adoptions. Adoptions is the part that this bill affects. In adoptions, the seizure is made under state law, and if it fits the circumstances that are suitable for the federal program, the local department, whether state or local, can adopt the seizure to the federal government, and then they would prosecute that, once again, not assuring a criminal process or criminal charge in that, could be purely civil. And so that gives you the three paths of forfeiture. So that third little section, about 30% of adoptions, is what this bill is looking to affect. So our process gives further protections to those who are not able to have their own attorney. They'll have a public defender. In this, because we are combining the cases and for more efficiency, the public defender would also represent the asset because that could be part of the sentencing. So it's essentially a piece of that case. So it's a small burden added to the public defender, very, very small. This is, we're talking about very few cases. I believe that over a 3-year period, Manchester and Nashua had 4 adoptions total for the 3-year period. So this is not a big money event or a big effort for the public defender. Of course, on the other side of the fiscal issue is the judicial economy of combining these cases. So with one process, you've got the criminal procedure and the sentencing and the asset forfeiture as one combined effort with all the same players working on the same files. In the current process, it's divided out. So you have the criminal process that happens, and then you go into the civil process, and you could have different judges, you could have different attorneys. You could have no attorneys because often citizens just default on the asset forfeiture side, particularly if they're convicted, which may or may not be a just punishment depending on what the asset that is forfeited. This bill, 1296, assures that in the forfeiture side of the procedure, that constitutional protections are made to assure that the penalty is proportional to the crime and that large asset is not given over for some minor, relatively minor. Obviously, these are felonies. So it used to be proportional, and that is determined by the judge. So the action getting here, this started as a rather small bill. It expanded with the Criminal Justice and Public Safety Committee. They actually kind of moved us towards a larger bill, looking at the efficiencies that would be gained by combining the criminal and civil processes. So it went from a small 1-page bill to an 11-page bill. And some of the parties on the other side were concerned about an 11-page bill. Half of this amendment that they received is actually just the existing text, and the other half obviously is added for the procedures that we're looking at today. So in committee, it came to a rather partisan vote, but as we got to the floor of the House, various discussions, the New Hampshire ACLU assured our friends on the other side that this was not some sneaky bill trying to put a bunch of language into statutes that they weren't familiar with. And eventually it passed the House on a voice vote, largely supported in bipartisan fashion, as most of our asset forfeiture bills have left the Judiciary Committee in the House. So I know that law enforcement, of course, is not interested in losing funds, and this does take a very small piece of funding. When you look at the percentages for any department, a department that has $60 million budget might be looking at losing $20,000 from this bill and this procedure. It's rather trivial. I know every dollar is important, but this is rather small. And certainly the folks at Law Enforcement Action Partnership have come out and supported this bill, and they certainly see the advantages, the benefits to the community engagement that law enforcement needs to have the trust of the community that assets are not just being taken and forfeited and particularly often defaulted. So in the end, this bill will improve judicial economy, enhance due process protections, and restrict circumvention of our criminal asset forfeiture laws. The time is right to send this legislation over to the governor. So with that, I'll be happy to take questions. And
I probably do a bunch of questions that belongs to the last board members yet, but I'm gonna wait and listen to everyone else and see if it gets taken.
okay. Thank you.
James Lane. Representative Sloan.
Gone.
Alicia, you guys.
You get the right list?
Oh. Yes, we do. We have Reverend Melissa. Lisa.
Please here.
Dan, you had the bench sugar on, you won the bench sugar contest last night. We won't talk about why we're in Hawaiian.
Good. Thank you, Mr. Chairman. And thank you, members of the committee. For the record, my name is Dan McGuire. I'm from Epsom, and I'm a former state rep, and I was the prime sponsor of the legislation that reformed this New Hampshire asset forfeiture law 6 years ago. What this bill does does not change the policies that we've had for those 6 years. The policies remain in place, and that the main policy change was to make sure that forfeiture, which is a kind of punishment, happens after conviction, right? So when somebody's convicted of a crime, then their fruits of that crime are subject to forfeiture. But originally, forfeiture and the criminal aspect were completely separate, the way they are in federal law, and that's just not right. That you get punished for something when there's no underlying criminal conviction. And so this bill was very nicely written, as Representative Sylvia said, by the House Criminal Justice Committee, and it streamlines the whole process in court. So the process in court used to be, or is, I guess now, two separate things. It's a separate criminal case and a separate civil case against for the forfeiture part. This merges those into a single prosecution and a single case in a single court. So the forfeiture comes after the conviction and becomes part of the penalty of the crime. So, I mean, just because it is a penalty, it's a punishment. And so the court and the jury can consider what's the appropriate penalty for the crime, including forfeiture. So it's mainly an efficiency sort of thing. The other thing that this bill does is it makes New Hampshire law used a little more often than federal law. So we like what's in New Hampshire law. We like those policy changes. And so this has New Hampshire prosecutors use New Hampshire law. That simple. Thank you, Mr. Chairman. Sorry. Thank you, Madam Chair.
Yes, I probably should. I probably do this a lot. But I'll ask you, so do you have a problem? I don't have a problem with separate treatment of I see when if you want to put them all together. I don't mind having a lower evidentiary standard to take your probably illicit drug money, as I do to, I want the highest possible beyond a reasonable doubt. You did the crime. I'm fine with the lower standard to take your illicit drug money.
Okay. Do you want me to?
So we might differ on that.
I understand.
You're saying that my property gets the same treatment as my person's body.
I guess I would say that taking someone's property is a punishment to that person. It's not really, you're not punishing property in some sense, right? You're punishing the person who owns that property. And if you're doing that, they should be guilty of something. I mean, it's that simple.
So again, so when I look at it, I'm like, here we find the guy in the FBI show tonight, and somehow they made a mistake somewhere along the line, and they can't get that criminal conviction because they can't quite make that evidentiary burden. But we're pretty sure you did it. Maybe not beyond reasonable doubt, and here's this $30,000 in cash sitting next to you, which we feel came from a drug deal, but we can't criminally get a jury to put you away for it. But if I have a lower standard, I'm probably going to get people going to say, yeah, that's illicit money and that should be taken. Okay. And you don't, we just have a difference.
I think so.
Okay.
And again, that particular difference has nothing to do with this bill, right? Because this bill is not changing that in any way. That's sort of already in New Hampshire law. But you're right, it's not in federal law. And so we are saying, let's use New Hampshire law, which the New Hampshire legislature and governor agreed to, right?
So did I miss something that we still could use? We're working, a lot of our drug task force are federal combined, and so you don't want the prosecutors to have the discretion to use the federal approach.
Okay, so on task forces, this bill does not affect them. They will still use federal law, almost certainly. Because they're joint between federal and state, right? But on things that are state only, they would use state law.
Last question, ma'am?
Yes.
Thanks. On page 2, it talked about, so you concerned more with the pettier things, like on line 23 on the $200 in the small vehicle. Is that what you're trying to protect mostly? Smaller amounts?
Yeah, I don't think I can.
I'll just withdraw that.
Yeah, because that's a little thing that was added. I don't think that that's that
Thanks
important.
for taking my questions.
Yeah.
Senator French?
Thank you, Madam Chair. Thank you, Representative, for coming today. So just to clarify what the other senator was saying over there, this bill says that for forfeiture, the state must use state law, not federal, and that you cannot lose your property just because I think you did it. I have to prove you did the crime before I take your property away from you. Is that correct?
Yes, in cases where there's no federal officer involved in arresting anybody or working the crime to start with.
Okay.
Yes. When it's just all state stuff. Yes.
Use state law.
Use state law. Yeah.
Just a quick follow-up to
This senator.
To this senator over here, to him. So again, he said, he used the word, you think it was. If there was a standard to take that property, it's just a lower burden because we're not considering it at the same right as a person, correct? There has to be proof to take the property. It isn't just what we think.
There has to be a criminal conviction.
No, before.
Not to seize. Okay. This bill has nothing to do with seizure.
Okay.
We've never changed anything to do with seizure. When someone's arrested and there's drugs and cash and guns and so on, all that stuff gets seized, right? And the question is, how does the court deal with the situation at the end of the day, right?
I'm good. Thank you.
Okay, thank you very much. Are there any further questions? Okay, seeing none, thank you very much for your testimony. Okay, the chair will call Richard Head. Thank you. Good afternoon, Mr. Head.
Good afternoon, Madam Chair, members of the committee. My name is Richard Head. I'm the Government Affairs Coordinator for the Judicial Branch. We do not have a position relative to whether or not the process for forfeiture should be changed. We do have significant concerns regarding the way in which this bill has been drafted and the implementation of it from a purely court mechanics and process concern. I think everything I'm going to say in my testimony today, I said in the House side too, and I did share not this exact document, but something similar to it with those who are involved in the drafting. And it still just strikes us as having significant mechanical problems. And one of the issues is it appears to be an effort to combine a model bill with the existing state law, and that merger is not clean and just creates some significant issues. When I skip, starting on page 4, not really a mechanical issue, just an observation, and I think the sponsor mentioned this. Page 4, beginning at line 2, where it says it would be part of the criminal prosecution. We are now, just to be explicit, shifting this from an attorney general function to a county attorney function for the most part, except for those cases in which the attorney general is the prosecuting authority. So we are now shifting this to a county attorney process, which they have not traditionally done. The following line after that, line 4, as also I think the sponsor mentioned, this would become a duty of the public defender going forward. It is not currently. I think roughly we're talking about 70 to 90 petitions are currently being filed by the Attorney General. So that's the rough scope of what we're talking about. We have heard repeatedly about shortages of public defenders. Then we get into sort of the process, and page 4, line 10, has a person with an interest in the property may petition the court for a hearing. So we have a new sort of filing. This is a petition that's got to get filed by somebody and is entering the court system. It's not a part of the criminal docket, even though there's words that have been said that these are supposed to be part of the criminal docket. We're talking about a separate petition, unclear exactly as to where that petition would be filed. Then going on, page 4, beginning on line 12 and working your way down, a court may hold a post-seizure hearing. None of this accounts for a bill that you heard last week, which if it passes, would repeal felonies first. Felonies first, or the repeal of felonies first would require felonies be filed in circuit court. If they are not pled at that stage, in the preliminary stages, we get bound over to Superior Court. We have, and I'll talk about a couple of the other ones, various processes that are out there that are going to be filed relative to forfeiture that are not the criminal case. And the thing that gets bound over is the criminal case. And it's unclear, and I'll talk a little bit about this, and some of the timing of these petitions, where they're being filed, and exactly how they get sort of hung on to a criminal case when we're talking about the filing of petitions throughout this. Sort of a side issue, in Superior Court, we don't have petitions anymore. We file complaints or criminal proceedings, but sort of a separate problem. With, still on page 4, line 26, in a case in which the state seeks forfeiture of property, the prosecuting authority shall file with the court a petition for forfeiture. Again, I'm not sure what that is relative to the criminal proceeding. It appears to be a separate filing, separate docket. And again, I'm not sure what court that's being filed in. It's being filed in the same court where the criminal case originated. And then if felonies first is repealed, what happens to this tailing forfeiture action? It just becomes very unclear as to how a separate petition is the criminal case. And how it sort of gets managed by the court system as we have these new these things that are called petitions being filed. Looking into page 5, where it says on page line 9, the court shall order the return of the property to the owner if the prosecuting authority does not file an indictment or information as provided in the court's rule. But at least everything that's been said is it's supposed to be tied to an indictment, the criminal case. So I'm not sure how the court can get involved in returning a property when there's been no criminal case filed and presumably then no forfeiture action. We don't have a case, we don't have anything to order against. Very unclear from our perspective on what that line means if there's no criminal action that's been filed. Page 5, line 12 talks about discovery in the forfeiture action shall be subject to the rules of criminal procedure. Our rules of criminal procedure in both circuit and Superior Court do not have a forfeiture process currently. So something new is going to have to get created there. In page 6, line 1, this is the third type of petition that can be filed. The defendant may file a petition to the court to determine before trial, at trial, or upon conviction whether the forfeiture is unconstitutionally excessive. Again, we are very unsure as to what that is. Is it a civil petition? Is it it is not apparently tied to the criminal case because, again, the folks who have the rights to petition are the prosecuting authority, anyone with an interest in the property, or now the defendant, where we have this sort of regular process of a criminal case, and this doesn't have a true docket connection to that case. Page 7, line 12, provides for what an innocent owner of the property can do. And that says an innocent owner may file with the court a simple statement that sets forth various things. I don't know what a simple statement is and how it gets docketed in the court, but on line 17, it says the court shall hear the petition. So I think the simple statement referred to on line 12 is a petition, sort of unclear. And it appears to be a fourth type of petition that can be filed in a forfeiture case, which again are not, as far as I can tell, tied or part of the criminal case itself. So my overall concern is it is a merger of processes that is not being merged cleanly. And we have an overlaying, and I understand it's not current law, but we have this overlay of the repeal of felonies first, which creates a very confusing procedural issue of felonies being filed in circuit court, then getting bound over, and only criminal cases get bound over. And then we have these 4 types of petitions that can be filed at various times by prosecutors, innocent owners, people with interest, or the defendant. So it's just from an implementation perspective, we're confused. And we think it just needs substantial additional work. We don't have any objection to sort of the concept. It's the mechanics as the bill is laid out. These are the same points that we made in the House side. We're happy to work with anyone, but I think it's just a very complicated merger process that needs work. And with that, I'd be happy to answer any questions.
Thank you very much for your testimony, Mr. Head. Are there any questions from the committee? Okay, seeing none. Thank you. Okay, the chair will call Danielle Sakowski.
Good afternoon, Madam Chair and members of the committee. My name is Danielle Sakowski. I'm a Senior Assistant Attorney General at the New Hampshire Department of Justice, and I currently serve as the Chief of our Direct Prosecution Unit, which pursuant to the current statute handles civil asset forfeiture for the state of New Hampshire. DOJ is opposed in large part to the proposed changes. To a large extent, the proposed legislation legislates a problem that does not exist. I would note, and I did bring copies for the committee members. that New Hampshire DOJ does have asset forfeiture guidelines on its website, and I've provided copies. Within those forfeiture guidelines, we have a lot of the protections discussed in this bill already in place. For instance, we limit cash forfeitures to amounts over $1,000. In terms of vehicles, it needs to be a vehicle that's worth $3,000 and typically less than 5 years old, with some exceptions. If someone is acquitted of the underlying criminal offense, we do not pursue the civil asset forfeiture. If a felony is reduced to a misdemeanor, unless it is part of a global resolution, we will not pursue civil asset forfeiture. I think that the bill suggests that there is these violations of due process happening statewide, and that's just not the case. Individuals are given, obviously, notice at the outset that their asset is potentially subject to forfeiture. The state then has 60 days to file a petition. That petition is served on the respondent pursuant to civil service statutes. From there, in a majority of the superior courts in the state, a hearing is being scheduled whether or not the person has responded. And additionally, pursuant to the statute as it's currently drafted, somebody can ask that the civil asset forfeiture be continued until their criminal case is concluded. Within our written policies, we as a policy do not object to those requests. In the 6 years I've been doing civil asset forfeiture at DOJ, I've never seen a judge deny that request when made by either side. So I guess overall, I would just say that a lot of these issues are not issues and are already being addressed either through the statute as it's currently drafted or through our in-house policies.
Okay, thank you very much for your testimony this afternoon. Are there any questions from the committee? Senator French?
Just, thank you very much. Can your in-house policies change?
I suppose they could. You'll see that the version I passed around has a 2007 date on it. They've not changed in the 6 years that I've been doing asset forfeiture with DOJ. In terms of how they could change, I would expect that maybe the limit in terms of the monetary value we're willing to take would go up. But other than that, I don't see those policies changing.
But they could. Potentially.
Thank you.
Are there any further questions? Senator Gannon?
Since I'm getting free legal advice here. Again, I'm rusty on civil asset forfeiture. It was 2 or 4 years ago. Am I correct that there's a lower evidentiary standard to take the property?
You're correct.
Is it a preponderance?
It is.
Okay, thank you.
Thank you.
Are there any further questions? Senator Khan, do you have a question?
I do. Thank you. So part of the issue that's been raised relative to this is the efficiency of doing this through a criminal proceeding versus the civil asset and the potential of going back and forth. And I'm wondering, you're opposed to this kind of, to this bill, but are you also saying that the efficiencies that are gained through this, that's intended here, that you don't believe that they are necessary?
I don't know that it.
I'm trying to understand that.
Sure. I don't know that it does make the process more efficient. And I don't want to repeat what Attorney Head said, but for primarily the reasons he outlined. He did touch on, and I would reiterate, that the proposed bill still has DOJ acting in some type of oversight capacity, but a majority of these cases would then go to the county. I don't know that it's more efficient to have 2 prosecuting agencies involved and weighing in and making decisions in the process.
So it goes to the county, assuming that felonies first is repealed.
I don't know that it would have anything to do with felonies first being repealed, but a majority of the civil asset forfeiture we do, the corresponding criminal case is prosecuted by the county attorney's office. We have a handful of cases that we are the prosecuting agency on, but that is the minority.
And just finally, it's an impressive document. Thank you. Hadn't seen it before. Are there a couple of pages in here that you just, maybe through email, you could point out, hey, look at. these as most relevant to this bill?
I don't know them off the top of my head, but I'm happy to email you the pages that have the specific policies that I mentioned today.
Perfect, thanks.
Are there any further questions? Senator Gaddis?
Since I have you, and I've asked enough stupid questions, but you can help me. So if we just combine it into one hearing, one trial, to take the material goods, we'll have to reach at that higher criminal burden then? To take the car or whatever, the $5,000 car, will that have to be a higher standard of evidence proof? Like a preponderance of evidence going up to beyond a reasonable doubt is going to raise by being in that criminal setting?
I don't know I think that's a good question, Senator. But having not drafted the legislation and not having.
That's a question because I have a terrible cold, but thank you.
Thank you.
Hey, any further questions? Seeing none, thank you very much for your testimony.
Thank you.
The chair is going to call Matthew McConnell.
Madam Chair, members of the committee. My name is Matthew McConnell. I am a detective sergeant of the Narcotics Intelligence Division in Nashua. I've been in law enforcement for 14 years. 5.5 of those years have been in the narcotics unit. My current position is a first line supervisor where I supervise the undercover narcotics operations. I am here to testify in opposition of House Bill 1296 on behalf of the New Hampshire Association of Chiefs of Police. Our department relies on forfeiture money to fund these undercover narcotic operations and to buy necessary safety equipment that we need and to purchase and maintain surveillance equipment that we use during these operations. This House bill appears to create more work for a court system that's already overburdened. The forfeitures are currently handled by the Attorney General's office, as previously discussed. This bill looks to combine the forfeiture hearings with the criminal hearings that are already handled by the County Attorney's office in most cases for us. So that leaves the question for us is whether the county attorneys are going to be handling the forfeitures or the Attorney General is going to be handling the criminal cases. This confusion and this delay could cause issues with the forfeiture funds themselves, which we solely rely on to run our drug unit. The AG's office currently provides guidelines for the asset forfeitures, which was already handed out to you. One of those examples is that was already spoken about, the seizure amounts. For us as a department, we go by those guidelines. We follow those guidelines strictly, and if anything's not clear to us, we reach out to the Attorney General's office directly, and they answer those questions for us. I see having those guidelines, those amounts not set as law, as beneficial. The amounts listed in the proposal were $200 for cash and $2,000 for a vehicle, which is a very low threshold right now in this day and age. The $1,000 for cash and the $3,000 for a vehicle is still pretty low, and that's not something that we're really near. We don't go much higher than that, but I think having it as a guideline would allow the Attorney General's office to up those amounts on their own and reduce the amount of cases that they are getting for forfeiture because of lower amounts that are being sent to them. Law enforcement's not arbitrarily choosing homes to search and taking assets without reason. The assets are seized through investigations that show a nexus between drug activity and the assets that are seized. There's no reason to reinvent the wheel. The drug forfeiture fund administered by the AG's office has served New Hampshire well and has helped New Hampshire continue to fight to keep the dangerous drugs off the streets of New Hampshire. I ask that you find this bill inexpedient to legislate, and I thank you for your consideration.
Thank you very much for your testimony. Are there any questions from the committee? Okay, seeing none, thank you very much.
Thank you.
Okay, the chair will call Lee McGrath.
Madam Chair, members of the committee, thank you for the opportunity to testify in favor of House Bill 1296. My name is Lee McGrath. I'm the Senior Legislative Counsel for the Institute for Justice. And Senator Gannon, I'm anxious to answer your questions about the standard of proof. But before I do, let me suggest that crime should not pay. It is a legitimate function for the state of New Hampshire to take possession through seizures and title through forfeiture so as to ensure that crime does not pay. Representative Sylvia and the co-sponsors of this bill are not advocating for increased profits for criminals. Instead, they are changing a process. It is a real estate play. It's changing the location where title gets transferred, where forfeiture litigation takes place. And in every change of process, there are some costs and there are some benefits. My colleagues at the Institute for Justice and I support this bill because the costs are small and manageable, and the benefits are great. Let me just very quickly, dive into a couple of those small costs. There was a discussion about interaction with the federal government. This bill does not change joint task forces, and more than 70% of New Hampshire's collaboration with the federal government involves joint task forces. It changes adoptions. Adoptions where I'm driving along the New Hampshire highway and I get stopped by a New Hampshire police officer and there is no DEA agent in sight. But the chief calls up the U.S. attorney and asks him to adopt the case. These are very small. In the last 3 years, Nashua only did 4 adoptions, totaling $25,000. This is a small additional cost on Nashua and Manchester that also only did 4 adoptions. What it does is that it puts that hypothetical where I'm driving along the highway and get stopped, it puts it in New Hampshire courts with New Hampshire values, with New Hampshire standards of proof. And for those few cases, a total of 18 in New Hampshire over 3 years, it takes it out. What are the differences? Well, one difference is that New Hampshire pays out to Nashua and other cities 45% versus the federal government that pays 80%. And so for Nashua, that $25,000 that they're currently getting from the federal government is going to be reduced to $12,000. So the incremental cost of this benefit of ensuring New Hampshire law to the law enforcement in Nashua is approximately $13,000. Similarly, this bill makes another small change to police officers and sheriffs, and that is that it puts a minimum on currency of $200 and vehicles of $2,000. It is, as the testimony from former State Representative LaChance points out, these are uneconomical for all parties. It's uneconomical for the police to process this paper. It's uneconomical for the prosecutors to litigate this. It's uneconomical for the property owner to pursue it. And Madam Chair, Senator Gannon, this is the inherent problem of civil forfeiture that has not yet been addressed. It is the problem of what happens when you go into civil court as opposed to criminal court. And the big advantage of criminal court is that you get a public defender. In civil court, you don't. Nationwide, the median seizure is $1,300. In Connecticut, it's $655. It is irrational for a Granite Stater to pay $2,000, $3,000, $4,000 to a civil attorney to try to get back those small seizure amounts. So the problem that exists with the two-track system is a problem of civil defaults. Up to 80% of Americans rationally walk away. They go home, they kick the dog, they have another beer, they curse the system that takes small amounts of money from them, puts them in civil court where it is uneconomical. There are other reasons. There are other reasons for defaults. But one big reason is that it is uneconomical. That is the only change for prosecutors. It is to engage in this real estate play, to merge the two systems. Madam Chair, Senator Gannon, it is already New Hampshire's policy to have a conviction as a prerequisite. It doesn't happen because people walk away in civil court from their property, and therefore that conviction, even if it were to occur, people have already defaulted, title has transferred, innocent people who potentially weren't charged with a crime, they lose their property. So the problem of a two-track system is a problem of defaults in civil court. This is not burdensome on the courts. And the way you might think about that, Madam Chair, members, is this is a lot like a sentencing recommendation. 90% of the cases are going to be pled out. In those plea bargains, this will take an additional 90 seconds to determine whether the car should be, title should be transferred, or whether the cash title should be transferred. This is very little incremental work to the public defender, to the prosecutor, to a private criminal defense lawyer. But in those 10% of the cases, this process says to the judge, you've heard all the evidence. You can dismiss the jury. You decide on your own, judge, whether the car was an instrument or whether the cash was the proceeds. Once again, that is one short hearing post-conviction. There are, as Representative Sylvia said, there are a number of new processes, but these additional processes come about because there's a constitutional requirement for a crim stock hearing, a prompt post-seizure hearing, and that's what this bill includes. Additionally, there's a process for wives and girlfriends and parents and Avis Rent-A-Car and the bank for them to go into court. But these are processes that must exist. And then thirdly, there is a process regarding excessive fines. And that's what my law firm won at the United States Supreme Court, the Timms case. And so this bill ensures that there are not excessive fines. Those are few of the costs associated with tweaks to seizure, different real estate, and a few extra processes that are required. But what are the benefits? The big benefit is that it streamlines the process. It consolidates into one process the prosecution of the person and the litigation of the property. In rem jurisdiction makes no sense when you have in persona, when you've arrested someone. And so by uniting them together, you're the state is rationally imposing a punishment linked to a crime. And that crime should be proven first. This is done. Secondly, it protects innocent owners. It ensures that no one acquitted of a crime loses his property. No one who is not charged with a crime lose his property. It also protects Avis and the Bank of New Hampshire, as well as wives, girlfriends, spouses, parents, and neighbors by creating these additional processes. Thirdly, it lives up to the obligation of Gideon versus Wainwright. In this country, we believe you, in this state and this country, you are due representation for all criminal activities. Keeping a criminal punishment in civil court belies that commitment to representation. This puts the criminal punishment in the right place. It puts it in the criminal court. It looks a lot like sentencing. It looks a lot like fines. It should be property owners, defendants should have representation. Fourth, this protects New Hampshire. This legislature matters. This committee matters. It has long been the tradition in the United States that states, not the federal government, set criminal code. In too many states and in too many times, your work is being circumvented by outsourcing forfeiture litigation to the U.S. attorney. This bill does not stop 70% of that. I wish it could. It stops a small percentage, the 4 in Nashua, the 4 in Manchester, the 18 total over, but it is a step in the right direction. And finally, as former Representative LaChance points out, the big benefit is one of reputation. It's a horrible thing to have your property taken and then find it's too expensive and justice isn't available to you in the upside-down world of civil forfeiture litigation. So in conclusion, Madam Chair, members, this is a better way to implement the policy decisions that you made in 2016. You set the bar in 2016 at beyond a reasonable doubt. But it was undermined by keeping the 2-track system, by changing the real estate, by changing where this takes place, by putting it as part of the plea bargaining and a part of the criminal prosecutions. You get it right. You get the right mechanism to realize the policy decision that you made 6 years ago. With that, Madam Chair, I'd be happy to answer your questions about my law firm, this bill, what Maine did last year by enacting it, what Vermont is considering a similar bill, and any questions that you might have about this legislation.
Thank you very much for your testimony this afternoon, Mr. McGrath. Are there any questions from the committee?
Sure.
Senator Gannon.
Mr. Gannon, let's do it.
I don't need it.
Senator, please.
I'm like the high school kid taking on Joe Namath, but so my chiefs are all residents of New Hampshire.
Yes, sir.
And they're also residents of, they're part of our federal U.S. government. And they're representing both. So you used an instance of saying the chiefs, 4 chiefs or something, had venue shopped.
4 times.
We'll use that word, venue shopping.
You may. I like real estate, but you can
use a different thing.
They went to federal.
So I'm looking for them, and I realize that they're maybe a hair short of beyond a reasonable doubt to take that drug money that we pretty much assure is drug money, but I can't get to that higher standard. But in the federal court, if I get to a preponderance, I'm going to get to take that stuff that I'm pretty sure has come from illicit gains. So my chief there, in your instance, sees that he's going to get more money for his towns, and he sees he's going to be tougher on crime. Maybe, and I'm not putting your body in jail, but I know I can damn well take your property. So to protect me, the citizen of New Hampshire, he's taking illicit gains and using a different route to get there. But you don't like it.
Yes, everything you said is true, Senator. Absolutely everything you said is true. But it is inconsistent with the policy of the state of New Hampshire that you enacted 6 years ago.
I understand.
You want someone to be convicted as a prerequisite, and then the low standard, once convicted, the low standard of preponderance is easy to. I fear that the chief may want to reverse the McGuire bill from 6 years ago and have a completely independent system. I think that would be a mistake, and that would be at the core of what this discussion is about.
Thank you for your learned testimony.
Hey, are there any further questions? Seeing none, thank you very much for your testimony this afternoon.
Madam Chair, it's always a pleasure to visit, so thank you for the warm reception and the good discussion.
The chair will call Ross Connolly.
Thank you, Madam Chair, members of the committee, for holding this hearing today. Just for the record, my name is Ross Connolly. I'm the Deputy State Director for Americans for Prosperity in New Hampshire, and here to voice our support for HB 1296. I'll be very brief. I don't want to repeat what Attorney McGrath said, but this bill simply combines two processes that will simplify the forfeiture process in New Hampshire. And one of the key points that Attorney McGrath made was the fact that in a criminal process, these individuals would have representation. Say somebody had $1,000 seized, they went to court, criminal court, and were acquitted. And to go to civil court, they don't have representation. It just makes no financial sense for them to then pursue their money in civil court. So combining this into criminal court makes complete sense. And also, just on top of it, the folks that are most prepared to handle the course against the property are those who just adjudicated the criminal case. So combining those two areas would simplify the process, speed the process along, and protect Granite Staters' due process rights. And that third point that this bill does, which addresses the federal adoptions program, as Attorney McGrath mentioned, 19% of all federal forfeitures in New Hampshire were adoptions since 2018 through 2020. 81% were joint task forces. Just want to really harp on that point that this bill does not touch joint task forces. It's just those adoptions, which in Nash's around $12,000 fiscal impact for a department that has a $60 million budget. So we're talking about a low impact, but sends a very good message to the people of New Hampshire that their property rights are being respected by the law enforcement here. Since civil asset forfeiture especially is one of the driving factors when you look at polling with the public, that one of the things that drives distrust between law enforcement and the public is things like civil asset forfeiture, where they feel like their rights aren't being respected. So for those reasons, we encourage the committee to move this bill ought to pass, and I'd be happy to take any questions.
Thank you very much for your testimony this afternoon, Mr. Connolly. Are there any questions? Okay, seeing none, thank you.
Thank you very much.
The chair will call Katie Horgan.
Thank you, Madam Chair, members of the committee. My name is Kate Horgan. I represent the New Hampshire Association of Counties. I am here today on behalf of the county attorneys. They are opposed to this bill. This will create additional work for the county attorney's offices. And as you are all aware, the county attorney offices already have very high caseloads and are understaffed. They would just like to point out that this bill fails to make any advancement in the system, and the present system run through the Attorney General's office works efficiently and effectively. And I'll just say that Attorney Head had pointed out many of our concerns as well, so I will not burden the committee, but happy to take any questions.
Thank you very much for your testimony, Ms. Horgan. Are there any questions from the committee? Seeing none, thank you. The chair will call Frank Knack.
Good afternoon, Madam Chair, members of the committee. Thank you so much for the opportunity to testify. My name is Frank Knack. I'm the policy director with the ACLU of New Hampshire, and we're here in strong support of HB 1296. My colleagues from IJ and AFP covered most of the material in our fact sheet, so I'll just talk about a few issues. One, just to clarify, Senator Gannon, in terms of the process, again, this is not changing the standards of proof or the requirements. So the person will be convicted as is under current law, and then it is just a preponderance of evidence to then take control of the property, to forfeit the property. And I think it's really important to note, as Senator French noted, if the DOJ pointed out that they have guidelines that are incorporating most of this, as they testified, most of these protections already in their process, but those guidelines could be changed tomorrow. And so we think it's important that we codify those guidelines and ensure that we have a process that protects the due process rights of all, regardless of who's in the AG's office today or tomorrow or a year from now. In addition, I just want to really talk about from the ACLU's point of view, the importance of ensuring that folks have access to counsel. And so again, under current law, a person is convicted, then it goes to the civil forfeiture process. For the forfeiture proceeding, that person is not guaranteed access to counsel. So you have people who are indigent, who may have had a PD in the criminal prosecution, and then even if that is their lawful property, which happens all the time, there is no ability for them to hire an attorney, particularly if we're talking about small dollar amounts, where the cost of hiring counsel would be substantially more than the cost of getting their property back. And again, when we talk about burdens, I think we should also remember the burden on the property owner here. We should be ensuring that we have a process that works. And if that takes more, we should ensure that the state is ensuring those resources exist. So thank you for the opportunity to testify, and happy to answer any questions.
Thank you very much for your testimony, Mr. Knack. Are there any questions from the committee? Senator Gannon.
Just to be crystal clear, so if I go the state route and I don't get a criminal conviction, I have no chance going for a civil asset forfeiture, right? It's dead. Right? You have
yes, you required criminal conviction
if I go
required.
the federal route and I'm a chief.
Yes.
I could prove by preponderance of evidence that the material item was criminally related and be successful there, yet not reach the criminal burden to put the person's body in jail.
Correct.
So I still don't have to get a conviction that, it has to follow suit. They'll be arresting, the prosecutor will sign off that he believes it was, illicit gains. Then I have a magistrate who's also going to have to believe this up to that level. So there are protections along the way. It's going to go through a whole procedure to take that property, which could not happen if I go to the state route. Is that correct?
Yes and no. I think, to clarify, there are some protections on paper, but I think in practice, particularly for indigent folks, those protections don't exist. And so you are right that under the federal system, it fails to meet the state standard of ensuring a criminal conviction before the property can be forfeited. But I think the problem, again, in the federal system is not only does it fail to require a criminal conviction, but it also, for indigent folks, that is a civil process. They are not entitled to counsel in those cases. And as Mr. McGrath from IJ talked about, we're talking about small dollar amounts in those cases. And so the cost of hiring counsel in those cases often is more. And I think it's really important to note in the civil forfeiture context how far away from the original intent of this law we've gotten. So, origins of civil forfeiture in admiralty law, back in pirates roamed the seas. And fast forward to the war on drugs, when we had civil forfeiture come to our shores, it was sold as this tool to get the ill-gotten gains of drug kingpins. Think Pablo Escobar, people who are beyond the jurisdictional reach of the U.S. government. And so we couldn't get to Pablo Escobar, but we could get to his property. And so we had the civil forfeiture process, which kind of made sense because he was beyond the jurisdictional reach. But fast forward to today, civil forfeiture, we no longer have that problem. We have people who the state has custody over, and they're just deciding to make it easier because they can't convict the person. And again, we are a nation of laws, and so we think it's important that the state will have its burden to convict the person before it then takes their property.
Thank you.
Thank you.
Senator French.
Thank you, Madam Chair. Thank you for coming today. So I believe we heard that this amounts to about $16,000 over 4 years between two departments. And so that amounts to about $2,000 per year per department out of a $60 million per year budget. Is that correct?
I'd have to look at the specific numbers, but that's approximately my understanding, yeah. So very, very small amount of, like, fraction of a percent, yeah.
So that's what we're spending 5 hours talking about. Yeah, thank you.
Exactly. And again, you know, that does nothing to keep police agencies from coming before their elected bodies to ask for appropriations if they need money for things. I mean, that's how the process should work.
Thank you.
Hey, are there any further questions for Mr. Knapp? Seeing none, thank you very much.
Thank you very much.
Are there any other members of the public that would like to come forward to speak on House Bill 1296? Okay, seeing none, we're going to close the public hearing, and the committee will be in recess until 5:30.
Nice. Nice.
Up to you guys. Yeah, well, it's time enough to, no, I'm all set. No, I'm all set. I'm good.
Want pizza or you want beer?
No,
Yes,
oh my God, no, I don't drink.
How are you doing? Thank you for pressing me up. How are you back in the That's better for us. Great.
Dudley? No, Senator Hassan, Senator Shaheen. Not Shaheen? What's that? Okay.
the committee will come out of recess. Moved by Senator Khan, seconded by Senator Whitley. We're just talking about the bills we heard today, and if there's anything that we would like to exec. What do you folks think about execing House Bill 1592, allowing
I think
parties?
that's ready.
Do you, or would you like more time? This one is about to create their own recordings. It seems like Mr. Head gave us testimony that it's unnecessary. These things are already recorded. They can request a complete recording without it being transcribed. So I'm like, why are we doing this? So is there a motion on House Bill 1592? Okay, we have a motion on ITL, seconded by Senator Khan. Is there any further discussion on House Bill 1592?
Yeah, I would just say, there was a woman here who had really compelling testimony, but I'm just wondering if her concerns could be addressed with a judicial conduct complaint, and maybe right. And so, that it was very compelling testimony, but I think her issues could be addressed in another way.
Well, and when I asked her how these personal recordings would help her, and she didn't have any real answer on how this would have helped her situation. So I'm ready for that one.
Yeah, and I was concerned about people taking those recordings and putting them out on social media. I think that we know that there's a lot of privacy fences around any kind of family court hearing.
Yep.
So if someone does it all on their own, what can the state do to prevent them from doing that? So I think based on the testimony we had, I think ITL is an appropriate motion. So we have a motion and a second. Is there any further discussion? Seeing none, all in favor say aye.
Aye.
Aye. Any opposed?
Move consent.
Okay, Senator French moves consent. Is there a second?
Sure.
Seconded by Senator Gannon. Is there any discussion on the consent calendar motion? Okay. Seeing none, all in favor say aye.
Aye.
Aye. Any opposed? Okay, Jenny, we'll do like we did before, that I will take all the consent calendar motions just because it's easier. She's only dealing with one person instead of five. Okay. Okay, another one that we heard today was House Bill 1612 relative to the confidentiality of reports made to the Division of Youth and Families.
You really want to take that one up?
I do not. I would like to talk to DCYF because we didn't get to hear from them.
Okay, that's fine.
Okay.
Next, we have House Bill 1614, an act requiring the recording and storing of digital video in all state-funded juvenile detention facilities.
I'd like to move interim study on that.
Okay.
Which one? Where are you?
We are on House Bill 1614, Senator, one that we heard this afternoon. I have issues.
I know. I have mixed feelings because, because of the horrible things that happened there. Like, we want to ensure that if those cases are prosecuted, or if there is a civil case, that they're held for the necessary.
This is years of video, okay?
Right.
In common areas where these abuses were probably in non-common areas.
Well, we don't know. We don't know.
Mr. Lehman, do you have a?
In jails and facilities, everybody knows where the spots that are reported are.
No, so that is true, and I have certainly, I've seen these videos, and they do bring kids to the corners, but now, everything, there are no holes. They're everywhere.
Not here. Oh, yeah, they are.
They are. I mean, we've talked a lot about this in HHS because of the bill to close the Sununu Center, and there is now video surveillance everywhere.
It's unfortunate that we didn't have the prime sponsor.
I know. I don't see the,
and
I mean,
testify.
what's the harm, we think, to holding these?
There is no harm. We're just talking about whether or not we should
Mandate.
exec these bills today. So if you folks want to hold these, I mean, that's okay, but I just wanted us to have an opportunity to talk about this bill. I mean, it's, like I said, it's unfortunate that the prime sponsor of the bill was not here. And it seems that all they really want to do is just extend the time from 3 years to 7 years to hold. But
Is
I don't
it
know,
7
just-
years, though?
I think
Can
that was-
charges be brought up to the 40th birthday of someone who was assaulted?
Yeah,
So it could be 32 years.
I don't know, because again, we didn't have the prime sponsor here, so we don't really have a lot of information.
So let's hold on this. I would
we
like to
will.
touch base with Representative Rice. She's a sponsor, and I know she does so much with the Senior Center, so maybe I'll touch base with her if the committee is okay with that.
Yep, that's
Okay.
fine.
All right.
Next, we have House Bill 1425, an act relative to the taking of real property by eminent domain.
You might want to hold on that.
I kind of
Pardon?
like
Oh,
move ITL.
Okay, I just, again, only one person testified on it, and I'm not really sure. We had no one else. Senator French?
I move
You wanna-
ITL.
Okay, but no, I mean, I thought you had a,
To discuss it?
yeah,
Well,
Senator Marr.
I was confused with this bill where they exclude, for the taking of property, they exclude personal property, and they added real estate and real estate improvements. So there's two types of property, real and personal. So if this is to the taking of private property and you exclude personal and real, I don't think there's any other property that can be taken. She mentioned something to the effect of
The refrigerated truck from
refrigerated
Shaw.
truck, which is personal property. I don't know. I was confused, and I
Yeah,
don't think
I
it's
mean-
necessary.
I'm looking at the statement of intent from the committee report, and you get to recover damages from attorneys and administrative fees and all these other things. So those are usually given at the discretion of the court, correct? Here, we're saying you must compensate for any attorney fees or anything.
I don't know if it's different in the broader context of eminent domain proceedings or not.
Yeah, well, we have a motion. Senator French moved ITL. Was there a second?
Sure.
Senator Gannon seconds. Is there any further discussion on this? It just seems kind of,
I agree.
okay. So we have a motion of ITL. Is there any further discussion? Okay, all in favor saying aye.
Aye.
Any opposed? Okay.
Consent.
second.
Consent calendar motion by Senator French and Senator Whitley. Is there any discussion on the consent calendar motion? Okay, seeing none, all in favor say aye.
Aye.
Aye. And any opposed? Okay.
Jenny,
Jenny, this one's me.
Sharon, take that.
What?
I said Senator
Nice guy.
Castro, take that.
And I think this last one, House Bill 1296, we just need a little time to look at this and see exactly what's going on with this.
I thought Richard Head's testimony on this was worthwhile.
Yes, I do too. But we received a packet of information from the Department of Justice as well. So I think we just received a lot of testimony, much like we did on the Parental Rights Bill, to give folks an opportunity, if you want to think about it, or just to see if there's something that we can do. Okay.
Felonies first was
Yeah, felony first
Interesting.
is key. So we'll see what we do with felony
Juxtaposition.
first, and then we'll take that one up.
right.
Okay, so what I have, and if I would have been here last Tuesday, and I apologize for not being here, it was better to be safe than sorry. I had all these bills that were ready to go.
And I was not here the previous week.
Yeah, I actually thought I had COVID, because the symptoms were the same. But I went to the doctors and had the testing done, and I was negative, so.
We saw you then on Thursday and you were
I was
chipper
negative.
and-
No, I wasn't.
Not chipper.
Oh.
You were there.
I was there. I was
there.
tired, but I was there.
All right.
So, okay. We're gonna take these up, I believe, in numerical order from what we have. House Bill 576, an act relative to Victims' Compensation Fund eligibility.
I'm a vote TP.
Okay, we have a motion about to pass. Is there a second?
Sure.
Seconded by Senator Gannon. Is there any discussion on House Bill 576? Okay, seeing none, all in favor say aye.
Aye.
Aye. Any opposed? Okay, is there a motion for consent?
So moved.
Second.
Moved by Senator French, seconded by Senator Whitley. Okay, any discussion on the consent calendar motion? Seeing none, all in favor say aye.
Aye.
Aye. Any opposed? Okay, and Jenny, this one's me.
Or Sharon.
No, it's okay. It just makes it so much easier for Jenny. She only has to deal with one person. Yes. Yeah. So next we have House Bill 579, an act requiring notice to the public before immigration checkpoints are conducted.
I move OTP.
Okay, we got it. Okay, Senator French moves ITL. Is there a second?
Second.
Second by Senator Gannon.
Hold on.
Okay. Let's have a discussion, because I think Senator Whitley has a different opinion.
Go ahead, Harold.
So I would like to see this ITL only because we're mandating the police to do something they really can't do easily. To get information from the feds in a timely basis and publish it. So we're mandating they do all these steps every time, every day, basically. They have to check with the feds. Are you having a checkpoint today? No, we're not. Okay. Are you having a checkpoint today? We aren't going to tell you. Okay. Are you having a checkpoint today? No, tomorrow we're not. That's what it is.
But it doesn't require, my understanding is there's not an affirmative, so they only have to inform the local media when they're informed of an immigration checkpoint.
And what does it do?
I look at this and go, what are you trying to accomplish?
Well,
Really, at the end of the day. And I understand what they're trying to do, but what it looks to me is you're trying to avoid people catching illegal immigrants. That's not our job at the state level. That's the job of the federal government. That is their mandate. And so by informing local police, who then are going to inform the local media, anybody who's an illegal immigrant will go, oh, okay, wait a minute. They're going to have this checkpoint here. I'm just going to go this way instead.
So
what good does it do?
are they going to have this right after the weather? So they give the weather for the state, then they show on the map and checkpoint up here. Come on, go on.
Yeah, I just don't know. What are you really trying to accomplish here?
Well, I think there has been a lot of media and litigation about how these checkpoints are used unlawfully. And so I think for more oversight over this issue, there's been litigation. There's been orders on this. They've been used unlawfully to find drugs and racial profiling, which they're not allowed to do, right?
This is a free stater bill.
Well, let me finish. So I think it's been shown that these stops have been, used as fishing expedition. We're talking about 579, right?
Yeah.
Okay. Right?
But is it, Senator, my question to you is it our job to police the federal government? We don't get to look at them and tell them, you guys can't do this, you can't do that, you can't do this, you can't do that. I mean, that's not our job. And to put that on our local police and say, look, they're gonna tell you, and then you have to get it out through your media. Either you've got to inform the press, put out a press release, or you've got to put it up on our website someplace. I mean, why are we doing that? That's not our job. That's not our responsibility as a state. This is the federal government doing what they want to do, what they can do, and they're allowed to do this.
You asked a question about Vermont and Maine.
I'm sorry, the what?
You asked a question about Vermont and Maine,
Yeah.
and we never got an answer. And
Whether they have a similar law to us.
what is their, do they notify or not?
I don't know.
I mean, there's some rationale in having some consistency along the northern border.
Right, because if we say, okay, you're gonna start doing this, they're just gonna say, okay, well, we're gonna go through Vermont, or we're gonna go through Maine. It doesn't matter, and that's the point. It's like, what is the purpose? Is it because people feel inconvenienced that there's a checkpoint and I'm gonna be driving down that road and I'm gonna get stopped and I don't wanna be stopped? I mean, I just don't see the purpose of this bill. Rick, you had...
Just the background on the idea of public notification of checkpoints comes from the DWI checkpoints 10 or 15 years ago. And the rationale was that the DWI checkpoints were supposed to act as a deterrent. And in order to make it constitutionally permissible to stop people against whom you had no probable cause, the Supreme Court required the local agencies to notify the public of the general time and place where these things were going to happen to maximize the deterrent effect relative to drinking and driving in an area. The question in the immigration context is whether notification of where law enforcement activity is going to be happening will have the kind of deterrent effect that will deter the illegal conduct that's the target of the operation. You can decide, but that's the background on the idea of public notification.
Right, and, and I just wanted to respond to you too about, it's not our job to tell the feds what to do, and I agree, but I don't think we're doing that with this bill. All it says is that if law enforcement is told, then they have to notify, and I think it's an important public transparency thing because of the litigation we are seeing about how these are being used inappropriately.
Senator, do you know of any cases of here in New Hampshire where these are being done?
Yeah, it was litigated. I believe it was litigated by the ACLU.
They
were successful.
litigated cases in which the feds would bring the local police officers in, and then the police would scoop up low-level drug things that they found in the stops that they made for people who turned out not to have immigration issues. And they've done some things with searches on buses and a number of things. And, our friends over at ACLU have, but those mostly involve, the relationship between state and federal governments and the federal government in the first instance, I think, for the most part.
No, they were found, there were civil rights violations.
Oh, yeah, absolutely.
Yeah.
Right, and those, again, are the federal government. That's why I just keep the federal government. Here we are, we're gonna say, okay, if you're gonna inform a local police department, they're gonna have to use their resources to inform the public that, hey, at such and such a time, on such and such a day, they're gonna be stopping people on such and such a road. I just don't see why we have to do that. Why do we have to inform the public of something that the federal government is doing? If they're doing it, let it be their responsibility, but we can't tell them that.
I think we have an obligation because they're our citizens, right? And we know that these stops are being used, for purposes that are not compliant with federal civil rights law. So they're New Hampshire citizens. So I feel like we do have an obligation to, in terms of transparency, to let, if we know about it, to let people know. Yeah.
I think we just have a fundamental disagreement. So
we'll do one.
Yeah, this will make an interesting floor discussion.
We gotta have something to talk about on the floor.
Madam Chair?
Yes.
It was Mr. Knack that you had that conversation with relative to Vermont and Maine.
Oh, Mr. Knack is here. Do you know Mr. Knack? Do you know offhand if Maine and Vermont have adopted similar legislation?
I did check on that, and I apologize for not responding to the maybe not, I understand that's the partner right now, but we also have a much different.
Okay. Right, okay. Okay, so we have an ITL motion. Is there any further discussion? Seeing none. All in favor, say aye.
Aye.
Any opposed?
No.
Okay, so it's a 3-2. Senator French, you want to take this one?
Sure. Oh, you get the tough one.
Yeah, he gets to argue this one. Okay, next we have House Bill 481 FN, an act establishing the Office of the Right to Know Ombudsman and making an appropriation therefore. Senator Khan, you have an amendment.
I don't have it yet.
You don't have it? I thought I had it.
I sent it to you.
Oh, okay.
But I sent it to you at the same time that I sent it to OLS.
Oh, and you haven't gotten it back
I
yet?
haven't gotten it.
Okay, well, we can save this one for
But maybe
Thursday.
tomorrow. Thursday, yeah.
Yeah, no, when you get it, please make sure to give it to Jenny and she'll send it out to the committee members. So we will do this one on Thursday. Okay, next we have House Bill 597, an act relative to the expectation of privacy. Is there a motion?
I'd like to interim study that a little longer.
I'll second.
Okay, so it's moved by Senator French, seconded by Senator Khan. Okay, is there any discussion on this bill? I reviewed all the testimony that we had, and I understand where they want to go. I just don't think this bill is ready to get there because they want to preserve privacy, but how is government supposed to talk to each other, different departments, in even different states? We belong to a number of multi-state compacts. And if we can't send information, how is that going to work? That's my concern. I mean, you can have somebody that lives out in Wisconsin and lost their driver's license in Wisconsin. They move here to New Hampshire, and New Hampshire, they try to get a driver's license. There's going to be no way for New Hampshire to find out from Wisconsin whether or not this person had an issue. So I just don't think this bill is ready to go yet. So, okay.
There was a lot of opposition.
Pardon?
There was a lot of opposition.
Yeah, I agree with that. I like I said, I mean, I know that we've passed this constitutional amendment about protecting an individual's privacy, but how do we balance that? And I don't think this bill has done that. So, okay, so we have a motion of interim study. Is there any further discussion? Okay, seeing none, all in favor say aye.
Aye.
Aye, any opposed? Okay, is there a motion for consent?
Move consent.
Moved by Senator Khan, seconded by Senator French.
No, if I can't be first, if I can't. I can't even hear it. I can't even hear.
No, you gotta be fast.
Oh, okay.
Okay, so we have a motion for the consent calendar. Is there any discussion on the consent calendar motion? Seeing none, all in favor say aye.
Aye.
Any opposed? Okay, this one's mine too. Okay, next we have House Bill 1011, an act relative to the penalty for criminal mischief. This was a bill that we had last year, and I think it was part of an omnibus bill, which the House said we don't like omnibus bills, and it died. Is there a motion?
Motion for it to pass.
Okay, Senator Gannon moves out to pass. Is there a second? I'll second
I knew you
because we're
wouldn't have
talking about it.
1011?
Yeah.
Yeah.
And we all know why, because Senator French doesn't like misdemeanors and things of that nature. But I think that a good case was made because we know public property gets defaced and it needs to be cleaned or repaired, and the public paid for it in the first place, and now they're having to pay for it yet again to be taken care of. So I believe Mr. Pfaff, I think he had testified there had been a lot of defacement and vandalism done in State House Plaza, and there really wasn't a lot that they could do about it.
Yeah.
So we have a motion of ought to pass. Is there any discussion?
Yeah. So I see where they're coming from. I do, but I feel like there wasn't a compelling case. You know, whenever I see something increasing penalties, I want to see a really compelling case about why that's necessary.
Oh, okay,
I just didn't see it in the testimony.
okay. Yeah, I mean, Mr. Pfaff is the COO of the State House, and he probably knows a lot more about things that happen than we actually do, because they take care of it usually before we see it. But it's not only here at the State House, it's in different places around the state. And so, we have a lot of monuments. Most of our town commons have monuments. Most of them are to the Civil War. Sometimes they get damaged by people. And these monuments were put up by the people. They weren't put up by the government. Many of these monuments, especially Civil War monuments we have, were put up by people that raised the money in their own community. And, I know it's just, I think it's an interesting issue, but I don't have a problem if someone's convicted of defacing public property, that they should have to pay a fine for that to help repair the damage that they caused. So
this could pertain to graveyards,
if they're public,
if
yes,
they're public property.
if they're public property.
It could, and it could pertain to college campuses, which I
Well,
gotta tell you,
someone-
it happens.
It's mostly kids. That's another problem.
Well,
Yeah.
no,
I mean,
not
if
really.
they deface, it's public property.
But a Class A misdemeanor as opposed to a Class B, help me on the difference.
Class B misdemeanor has a, is finable an amount of $1,200, and a Class A misdemeanor is punishable by up to a year in jail and a fine of $2,000. And just for context, the rest of the statute defines criminal mischief as a Class A misdemeanor if the value of the damage is between $100 and $1,500. I'm sorry, defines it as a misdemeanor. Doesn't say whether it's Class A or Class B. And this would make damaging public property a Class A misdemeanor. When it doesn't say whether it's Class A or Class B, the prosecutor can decide whether to charge it as an A or B. When it says it's a Class A, there's some dispute out in the world about whether the prosecution can still bring it as a Class B. I think they still have discretion to charge it as something lower than the maximum sentence, but there are prosecutors who say no, so.
It just seems really steep, and I'm not saying that this is not, something that should be happening, but I'm thinking about who's doing this. It's likely kids, right? Kids, young adults.
Drunk, get old men.
It feels like it feels a little too steep for me to feel comfortable with.
But if it's a kid, they're gonna go through juvenile court.
Young adult, excuse me, young adult.
If it's a,
Young men's brains are not fully developed until they are 25.
I'm sorry, no, oh,
So says brain science.
yes, I know. Like I've said on the floor, we need to give our young people here in New Hampshire a card that has a sliding scale so they know what they can do at each age, because it's like, we used to have age 21, that was it, 21, and now it's like, well, it's 16 here, it's 18 here, it's 21 here, it's 25 here.
Senator Whitley, would it matter to you if the Class A was taken off of that and it just said a misdemeanor? Does that make a difference?
I'd be happy if we just made it a violation. Oh, it is just a
It
violation.
is a violation, and it's difficulty enforcing it. That's why.
Jay's trying to lower it to just a
Yeah.
misdemeanor and it'd be more discretion then.
He's got to raise it to a misdemeanor. So
From the
I
violation.
tried to keep it a violation.
So you settle in between you at B. Just make it a misdemeanor and then you don't put
It's
either.
all up to Senator Khan now.
Do you like that, Senator
Yeah,
Khan? You just put
it-
misdemeanor? With the
Well, it
discretion?
was originally a misdemeanor, so, it's a violation. Well,
It may,
you just want to put misdemeanor and give the discretion to the court?
can you take a pass on it till Thursday? I noticed
Okay.
something about the statute that.
Okay, so we had
No.
motion to, what
I
was it?
withdraw, no. we just
Okay, so we have a
withdraw.
motion, so we'll just withdraw that and we'll take this up on Thursday. Okay, next we have House Bill 1086, an act relative to concealment of a cause of action. I have here, I'd like to move ITL on this one.
I'll second that.
And second, we have a discovery rule. And this was like, okay, why are we, again, why are we doing this? And that's the question.
We're on 1101, right?
No, 1086.
1086. And it was brought forward for a constituent of the prime sponsor, but it just didn't seem to make any sense why
Right, and I
we were
think,
doing this.
I think, the constituent had, as always, a story that was compelling, but I don't think that this bill solved the problem. In fact, I don't really even know what it was doing. Yeah.
Yeah, I mean, and he did talk about how he filed a lawsuit and filed grievances, and I mean, we already had this in discovery, so why are we reinventing the wheel? So we have a motion of ITL. Who seconded?
I did.
Oh, okay, there we go.
Bipartisan.
Okay, there we go. Okay, is there any further discussion on the ITL motion? Okay, seeing none, all in favor say aye.
Aye.
Any opposed? There's a motion for consent.
So moved.
Second of French.
Second.
Okay.
Another bipartisan.
Yeah. Okay, so, is there any discussion on the consent calendar motion? Okay, seeing none, all in favor say aye.
Aye.
Any opposed? Okay, Jenny, that's in line as well. Okay, next we have House Bill 1206, an act relative to the source of funding for appointment of counsel or other services for indigent persons.
Move on to pass.
Okay, Senator French moves up past, seconded by Senator Gannon. Okay, is there any discussion on the past motion?
Seems just like a housekeeping.
Yep. Yep, this is the housekeeping. Okay, so we have an ought to pass motion. Okay, is everybody ready to vote?
Yep.
Okay, all in favor say aye.
Aye.
Any opposed?
Move consent.
Senator French moves consent.
Second.
Seconded by Senator Whitley. Okay. Any discussion on the consent calendar motion? Seeing none, all in favor say aye.
Aye.
Any opposed? Okay. Line two, Jenny. Okay, next we have House Bill 1239, an act relative to habitual offender hearings.
Oh, can I ask Senate Counsel a question?
Please.
Okay, so I wasn't here for this, but I was listening. And because this is a notice issue, is there anything else that we only do first class for notice?
That's the worst kind of question. I
Is it
don't
a
know.
hard one?
Well, there could be things, nothing comes to my head right away. But that doesn't, I can't give you a strong opinion that there aren't any.
Yeah.
So I have a note about, in the instance where first-class mail fails to be delivered.
Oh, right. That was the question.
That, in that case, it would default to a certified mail.
Right.
How would and what does that mean, first class failed?
If they,
Failed to be
They say-
delivered.
right, if they get like return to sender,
No, first-class mail's a 52-cent stamp on it and slap it in the mail. That's first-class mail.
No, she's saying if
but
it
what I'm
failed.
saying, if it fails because they go to deliver it and that person no longer lives there.
If it
Or-
fails, they'll be defaulted, and then the notice of default will be served in hand. And they'll get the notice of the default and say, what? I've never seen this before. And have to go back to the hearings department and ask for the habitual offender certification to be stricken and let them have a certification hearing.
Right.
So that was the question about if that's their process.
Yes.
Great, it's not in here, but it's fine. I'm not
We-
losing
we
sleep
do-
over
yeah, we
it.
didn't, I don't think we needed to spell out all the process. We did, I remember Mr. Casco saying that if someone missed the hearing, they usually give them another one. It's not an issue. This was just about changing how they notice to a first class. And again, if they don't, if it fails, then that's when that's when other things kick in, so.
Yeah, he didn't object to putting that in here,
To what?
the default in the event. Okay, so the default order shall be served in hand.
And, yes, that was put in by the House.
We have,
Okay, so we
Motion
have.
for it to pass.
Okay. Yes, Senator Gannon moves on to pass,
Second.
seconded by Senator Khan. Is there any further discussion on House Bill 1239? Okay, seeing none, all in favor say aye.
Aye.
Any opposed? Okay, is there a motion for the consent calendar?
Move consent.
Senator French moves consent.
Second.
Senator Whitley moves section.
You beat me to it?
You
Okay,
today.
all right.
Okay, is there any further discussion on the consent calendar motion? Okay, seeing none, all in favor say aye.
Aye.
Any opposed? Okay.
Bless you.
Thank you.
Okay, then this one's you.
Bless you again.
Okay. Next, we have House Bill 411, an act relative to transparency of federal agency operations within New Hampshire.
1411?
Yes, 1411.
Okay.
This is going to require the Attorney General to request information from federal agencies operating in New Hampshire and to compile and display such information on a website.
I move ITL.
Second.
Senator French moves ITL, Senator Gannon seconds. Okay, some of this sounds a little familiar, but I mean, do we want to go really down this road of requiring them to give us this information? And because it requires the Attorney General to request information from federal agencies.
Yeah,
They're not obligated to do anything.
exactly.
So-
This is very different than the previous.
Yeah.
Right.
This is what I get confused with the requirements and the checkpoints, but I still don't like the checkpoints. But yes, this is
Yeah.
the one.
Yeah, to request, okay. So we have a motion of ITL that has been moved and seconded. Senator Gannon. Okay, so we have an ITL motion. Is there any further discussion on the ITL motion? Okay, seeing none, all in favor say aye.
Aye.
Aye. Any opposed? Okay, so motion for consent,
So moved.
moved by Senator Whitley.
I would like to second that motion.
Okay. Senator French is going to second. Is there any discussion on the consent calendar motion? Seeing none, all in favor say aye.
Aye.
Aye. Okay, and Jenny, I will take this one out. Okay. Next, we have House Bill 1461, an act increasing penalties for littering.
Move ITL.
Senator French moves ITL, seconded by Senator Gannon. This is another one where the state rep was not available. The only person who testified was Jason Stock.
That was under duress.
Yes, and we should note for the record, it was under duress. He really didn't want to testify, but we needed to have somebody testify on this bill. Okay, so it's increasing a fee and a fine for picking up trash in the right of way. Would have been
funny.
Yeah,
And
okay, so.
passed the House almost unanimously.
For
Current fine is $62 for the first offense.
Yeah, what if you were throwing like money out the window? Is that considered
littering?
And then would you have to pay?
You know what I was actually thinking of is campaign signs.
Yeah,
Yeah,
right.
oh yeah, campaign sign, political litter.
I was thinking
call it
about
political
cigarette
litter.
butts out your window when you're going down the highway, just keep.
Yeah. Rick, you seem to want to say something.
He's pointing out the consistencies and inconsistencies in our conversation.
Yes.
current law is it's a violation which is punishable by up to $1,000 fine. The new language says it shall be fined $300 plus penalty assessment. That's not usually the language you use when you're creating a mandatory minimum fine or punishment. So it's not clear from the language in the bill the way it's drafted whether it's intended to be a mandatory $300 that everybody's going to pay and the courts have no discretion to suspend, or whether $300 is the new maximum for the violation.
Right, so maybe because of that, I don't know who made the ITL, if you would consider withdrawing to do an interim study, just because the Department of Transportation did come in and say what a big problem littering was.
Oh, interim study's fine.
Okay, so would you?
I would withdraw my
Okay,
motion.
so,
Yeah,
and you're gonna
I'll
make
second
a,
that. No, I second the motion, for interim study.
okay, so we have a motion made by Senator French for interim study.
Sure.
Seconded by Senator Khan. Okay.
It's agreeable today, isn't it?
Oh,
I don't think we'll be too agreeable by Thursday. By the time we hear all these bills. Well, no, by the end of the month, I think.
I'll
It's
give you
probably
another
gonna be-
rationale for interim study. It says that the state expenditures on this would be $97,000 because there would be system programming changes and reprinting of the uniform fine schedule.
there you go.
Sounds like an exorbitant amount, but
Right,
more to the point of interim study on this, might clarify, is that really the case?
this needs work. It would have been very helpful for the representative to be here to really give us an explanation. So, but unfortunately, that didn't happen.
Yeah.
So we have a motion of interim study. Is there any further discussion on the interim study motion? Seeing none, all in favor say aye.
Aye.
Aye. Any opposed? Okay, is there a motion for consent?
So moved.
Moved by Senator Whitley.
Quickly by Whitley. And,
Ooh.
Ooh. Are you seconding?
I will second
Okay,
that.
Senator
Thank you.
French seconds. Okay, is there any discussion on the consent calendar motion? Okay, seeing none, all in favor say aye.
Aye.
Aye. Any opposed? Okay, Jen,
Sharon, you want to take that one out?
I will take this one out. Okay, next we have House Bill 1475, an act relative to the enforcement authority of liquor enforcement officers.
Move on to pass.
Okay.
I'll second that.
We have an pass motion by Senator Khan, seconded by Senator Whitley. Is there any discussion?
Do we really need this?
It's a housekeeping bill, Senator.
That's what I was wondering.
Well, they seem to.
I have it as ought to pass. I just wanted to discuss it a little bit.
Okay,
Do we really need this? Say yes.
yes.
Okay, good.
Okay. He's getting a little punch happy today.
I think so.
Yeah, so, okay, so we have an ought to pass motion on House Bill 1475. Is there any further discussion? Okay. Seeing none, all in favor say aye.
Aye.
Any opposed? Okay, is there a motion for the
Move
consent?
consent.
Okay,
Second.
Senator French moves consent, seconded by Senator Whitley.
I'm a lady, I let her finish before she.
I'm an auctioneer.
He's an auctioneer. Hand him the
It
gavel.
does explain a lot, doesn't it?
I mean, he'd go, blah, 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 and we'd all be sitting here going, what?
I know.
Okay, so we have a consent motion that's been moved and seconded. Is there any further discussion? Okay, seeing none, all in favor say aye.
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 Any opposed? Okay, all right, Jen. Okay, next we have House Bill 1505, an act establishing concurrent jurisdiction in juvenile matters with the U.S. Department of Defense for coordination with the military family advocacy programs.
I move OTP.
Okay, Senator Whitley moves on to pass. Is there a second?
I'll second that
Seconded by
motion.
Senator French. Is there any discussion on the motion? It's pretty self-explanatory.
Yep.
It is. It's such a localized issue.
Mm-hmm. Okay, so we have an ought to pass motion. Is there any further discussion on the ought to pass motion? Seeing none, all in favor say aye.
Aye.
Any opposed? Okay, is there a consent calendar
So
motion?
moved.
Moved by Senator Whitley,
Second.
seconded by Senator French.
Is anyone, should I oppose this? Wouldn't you like to debate whether P is airport?
Okay,
We're just cutting you off at the pass by putting these on consent.
okay, we've got a consent calendar motion, okay. All in favor say aye.
Aye.
Any opposed? None, okay, and Jenny, I'll do this one. We just have 3 more left, I believe.
Got it.
We have House Bill 1577, which is an act relative to exemptions from prosecution for victims of human trafficking.
I move OTP.
Second.
Senator Whitley moves up to pass, seconded by Senator Khan. Is there any discussion? I do believe that we have discussed this bill over the years at length, and I think this is a good move to help victims of trafficking.
Why did it fail last year?
The next two.
It was in an omnibus bill, that's why.
Thought that was it.
Yeah, it was in an omnibus bill, so. Okay, so we have an ought to pass motion. Is there any further discussion? Okay, seeing none, all in favor say aye.
Aye.
Any opposed? Okay. Is there a motion for the consent calendar?
Go ahead, Whitley.
So moved.
Senator Whitley moves consent. Senator Khan seconds. Is there any further discussion on the consent calendar motion? Seeing none, all in favor say aye.
Aye.
Any opposed? Okay. Next, oh,
No, that's
I
it.
think that's it.
Yeah.
That is it. Oh, no, wait a second. We have, no, there were 2 more. One was 1388, an act relative, I think that this one might need, I'm not sure. This one, the, okay. Yes, okay, these were ones that I think just needed a little bit of work. Okay,
Yep.
all right. So is there,
Move we come out of executive session.
Senator French moves.
Second.
Executive session, seconded by Senator Whitley. All in favor say aye.
Aye.
Any opposed? Okay. Thank you very much, and I'll see you
Wow,
all
guys.
Thursday morning.
We concluded before it's 6:30.
Yeah, I know.
Guys were so convinced by our arguments to go with this by so much of this.
Okay, so,
9 o'clock on Thursday.
yep, 9 o'clock on
All
Thursday.
day long.
Believe me, I'm not thrilled with doing this, but this is
The
what we
only
have
way
to
to get it
do.
done.
Unless you'd like to come in on Saturday.
Ooh. An offer we can refuse.
I'm sorry, yes, I know. I have them in my office. I'll have them ready for you to schedule. It's for next Tuesday. And, yeah.
Such a potpourri of issues.
Oh, I know. It's like, oh my goodness gracious. We got a little bit of everything here. A little bit of everything.
All right.
If we don't get to these on Thursday, we'll get to them on Tuesday.
Okay.
So,
Into the restroom.
this is like the never-ending dust pile, that just when you think it's getting cleaned up, it gets bigger.
Yeah.